Hey guys, it's Kathy. I hope you're doing well. We got a good one today. I can't wait. We also have Judge Fleischer picking a trial for his next, his this week's adventure, and hopefully we get to see the verdict this time. Hi, Shauna. Oh, Mike. So I'm just super nervous because my streaming software crashed and it seems to be working well now. So let's just hope it stays like that. Hi, Sarah. I can't open Discord. And because my streaming software is unstable, I'm not going to try to worry about it. I don't know why it's not opening. So I can't post this link in our Discord channel. Fozzie's going to yell at me, but you know what? I don't see Fozzie here. So it looks like I'm good. I'm not going to get yelled at. Hi, Thor. You're on time. I'm so proud. Oh my. All right, so we're going to go into the divorce first. Hi, Tammy. Um, but there's just one tiny little technical issue that I'm going to fix real quick
What you're in.
right here. It'll just take a second. That's good. All right, we're starting at 2 minutes in because when I separated the video yesterday, I don't know why I caught 2 minutes of the audio from the last video. And I just found that out now. Hey, Cha. All right, Cha's here, so now I can get rocking. And Froggy's here. Everybody's here. Man, this chat is full already. Woohoo. Okay, so for those who are new, we got a divorce going on of a presidential candidate, lawnmower guy, poet. Hi Jim. He's a poet, so I don't know. Kelly's got probably gonna put some nice limericks in the chat today. And what had happened before was this lawyer was meticulously going through every single item that they own down to the last tissue, and now she's done. All right, so she's only gonna talk for another minute or so. No, well, a few minutes, not 1 minute, and then he's gonna start questioning. He's pro se, so he's gonna start questioning. Carolyn, remember how she spoke yesterday, the wife, and then listen today because her Wisconsin accent just flies out when she gets mad. It's very cute. It's not too thick, but I wish it was thicker. But here we go.
Employment insurance, that there's some sort of issue because of an address change. Can you tell the court about that?
So the last time I called, they wouldn't talk because the address, they verified that, and it's not me, it's Gabriel, so they have to, and it's a P.O. box addressed to him. So again, that was lower on the totem pole. I tried the vehicles and I've been working through the list. I only have so much time with the care of the girls, but he hasn't, I've put it out there that he needs to help do some of these, rectify these situations that he created by changing the address. He took the business phone number, but doesn't respond to anybody. He has the business email, doesn't respond to anybody. So it's very challenging to try and rectify these situations when I'm only getting them now after it's been 6 months to a year, or if somebody stops at the door. So I feel like he should have to step up and start having to fix some of the problems that he created.
So are you in a position?
Allowed to return back to the property.
I'd have Bernadette, I don't understand why this is so complicated. You don't get to argue. Go ahead.
Ms. Bernadette, are you in a position at this point to open your own business so you can start fresh with the clients that you've been servicing or have agreed to follow you?
As soon as I'm awarded the divorce, yes.
Are you asking that in as much as people have claims against Mad City that can be collected upon, that be Mr. Bernadette's responsibility to do that, especially in light of the fact that according to the division of assets and debts, he's getting more than you are.
Yes.
Now, you've been through bankruptcy. You know that may be one of the options. If Mr. Bernardin files for bankruptcy and they come after you, then that would be one of the reasons you would be able to come back in for maintenance, right? That's what you're asking for?
Yes.
Where is your passport?
Gabriel has it.
What makes you think that?
It was in the fire safe at the apartment, and my passports, my birth certificate, my social security card, along with the girls' birth certificates, which you get 5 free when you're in the hospital. So he has all of those, their social security cards. Those are all those documents were in the fire safe in the office, and they're gone. So since I didn't have access to them and they're gone, unless he gave them to Matt.
They're right on the desktop. Right on the desktop, right where I left. Either in the fire safe or on the desktop. Nothing's ever changed. I don't need any documents. I don't need any things. I have nothing here. I didn't move.
Ms. Bernardin, did you look for the safe and or on the desktop for these documents?
Yes, we've been going through documents and
Were they there?
stuff. No.
Are you asking that Mr. Bernardin either surrender them, or if you have to go get them, that he be required to reimburse you for that?
Yes.
I have a question that we didn't talk about. So I'm sorry about that. With regard to these assets that are being awarded to him, I know you talked about wanting him to come get these so that they're gone. Do you think that there's a need to hold on to some of them until some of these debts are paid?
As far as,
You know, if you can sell
the time and the energy and the money that I'm going to take on it, I'll take a loss. If he wants to sell them, then he can sell them and he can use that to pay the debt that he owes me. But for me to deal with that, having people come to the house, doing all of that is, first of all, I don't need a bunch of people coming here with the children and things. I don't have the time to do that, and nor do I really even want to take it on. I've already done enough headache trying to do what I can to make the situation better, to try and smooth over when people are calling me and threatening me and sending letters, and they're like, you know, you've ignored me for 6 months, and I'm like, I didn't. So if he doesn't want these items, he can sell them. That's fine. Or he can give them to Matt and Matt can sell them, or he can do.
That's what I was just going to say.
Wait
a minute. Let me go. So when he wanted things out of storage, he was able, we heard Matt testify that he, like, when he was busy, he found a crew to go get things and he was selling them. You found it on Marketplace, right?
Correct. So when Gabe originally decided he was going to move assets over to the apartment, it wasn't like we had told the girls. He came in the house. We were gone at a birthday party. We were supposed to be gone all weekend. He didn't realize we were coming back from one and going to the other one. We came home in the middle of him taking what he wanted from the house. Now, this was extremely upsetting to the girls when they don't know kind of what's going on and everything. And so he took what he wanted. Then when he went to Florida, he again took what he wanted. He has pictures that girls drew. He put things in storage up until that point. Didn't matter if it was the girls' snowboards, girls' toys. And then he gave them to Matt, so Matt could give them to his kids. So it didn't matter if it was mine, Gabe's, whatever. So he took what he wanted, and then whatever is left. And now he's saying that it's his bed, his this. And
I had an objection. What was your objection, Mr. Bernardin?
There was absolutely nothing of my kids in there. You can see all the pictures that she put.
Okay, Mr. Bernardin, I try to give you a chance because you used the word objection, but then again, all you try to do is argue with whether she's telling the truth. That's not an objection. It's not an objection.
Okay.
Ma'am, please go ahead.
Matt testified he gave the brand new snowboards that were meant for our kids to his kids this Christmas. So when you say there was nothing of the kids, and these are things that I know were missing that I've brought up. So there's lots of things that I don't know that I don't know where they went. And so if I don't bring it up, is it just not going to be discussed? And so this whole process has taken what he wanted, done what he wanted. I've tried to protect the money. I've tried to protect the assets. I've tried to listen to what the courts have said, and yet he'll find a workaround. You tell him he can't write a check, he'll pay it through PayPal. There's always a workaround. He can figure it out. And he's taken what he wanted. And I've had to sit and I can't sell anything. I can't do anything. I've just had to sit here and my family has supported me. But at some point, that's going to dry up. Like, I can't keep, yet he's used the money from marital waste, I mean, to the tune of $94,000 in 1 year on just his spending. And as you've heard, he will justify everything as the business expense. So it's challenging to have a voice or an opinion because I'm never right. Yeah.
All right, I'm coming to a conclusion. One of the things we talked about this morning that I'd like you to share with the judge, you went back and took a look at what kind of revenues were coming in from the businesses before you filed compared to after you filed, right?
Yes.
And so specifically, you were looking at the winter clients and income, correct?
Correct.
And you explained to me that season's like October till April, more or less. Am I right about that?
Yeah. So we would get seasonal accounts that would bill 4 times a year. The billing would start October 1st, which the payment then would be, so it'd be November, December, January, and February would be when the payments were due, but they would start being billed in October for the seasonal accounts. And we usually had a decent amount of seasonal, which means they pay those 4 payments, flat rate, doesn't matter how much it snows, that's what they're going to pay. And then we'd have your residentials that paid per push when it snowed only then.
And so can you summarize the type of revenues for the winter clients in the fall of 19 through the winter of 20?
So in that year, salting services were 22,000 and snow was like 144,000.
So about 164. How about for the next year between 20 and 21?
Salting was 12,600 and snow was 132,000.
And then the year of the divorce, so the 21 to 22?
So that one went 7,500 in salting and 71,200 in snow.
And then the year 22 to 23?
Salting was 7,230 and snow was 23,200.
So,
but
what do you attribute? What do you think caused there to be such a significant decline in the contracts and the payments that were coming in the year after the divorce was filed?
So based on the invoices that were paid from Mad City to Earthscapes, which is a subcontracting company, there are clients that they're billing for that are not in the Mad City QuickBooks. So they had to be filtering through Yahara. So he was filtering money through Yahara because it didn't come through Mad City.
So I
have an invoice.
Yeah. So what I just want to make clear, you can see that Mad City was paying for someone to do the work, but there was no revenue coming in for that work.
For that client, correct.
Are you an active participant in any branch of the military?
No.
Are you asking the court to grant you a judgment of divorce today?
Yes.
Are you asking the court to incorporate the prior judgment of the court regarding custody and placement and modification of support based on $60,000 of imputed income?
Yes.
Are you asking the court to deny any claim Mr. Bernardin might have for maintenance against you?
Yes.
Are you asking the court to hold open any claim you might have against Mr. Bernardin for maintenance for the reasons that you discussed during your testimony?
Yes.
I have nothing further, Your Honor.
Ms. Bernardin, a follow-up I have is, I guess I didn't quite follow it. If I understood correctly, you do still want, and I think in a temporary order I had awarded, you get all the business, meaning you can have all the customers, any goodwill, things like that, correct?
I could take, if I wanted to take on, yes.
Exactly, that you would be the one with the right to do the first choice, essentially.
Correct. As I don't know if you're saying there's a value to them at this point, clients can pick where they want. And since when he left last year, he said he had his clients taken care of. We found out that wasn't true. Matt owed money. So clients weren't happy. So there is like no value, like to say, oh, that these clients come with a value. No, I have to earn them. So I don't know if you're thinking if I get the business, they have a value to them.
That is a next question I have is, I assume you've been at least trying, because I've given you some rights to service clients and to try to run the business. Do you have some that are currently with you and that you expect you'll get to keep unless they would choose to go elsewhere for whatever reason?
No, I have. So I had about 23 last year when we had started. And then I picked up, was up to about 30 at the end of the season because of the ones that Matt wasn't servicing and they came to me. I have about 20 right now, which is about all I can handle with the care of the girls. Starting my own company, I'm working with a business attorney and have been advised to wait till I'm fully divorced before I fully reopen that venture. Because
do you have any idea of the value of those 20 clients that you're going to keep that were from Mad City?
It depends on the growing season. I mean, and some are every other week. So, $1,000 a week, maybe. I haven't added them all up. I'm just strictly mowing. I'm not fertilizing, and I can't do snow removal because obviously I can't time when it's going to snow, and I can't leave the girls unattended and have them ready for school or events. And I can't expect my mom to get those, if I'm out for 24 hours or 48 hours, I can't have her. So I'm strictly doing lawn care. So I would say $1,000 a week roughly right now, but that is only from April to about November is all I'll be earning that. But then that'll have to carry me through the full season because I can't do snow removal because I have the care of the girls, if that makes sense.
It does, yeah. Mr. Bernardin, do you have any questions you wanted to ask Ms. Bernardin?
Yeah, I have a lot of questions.
Do you think we're going to be able to wrap up today, or do you have a ton of questions that it's going to take more time?
Yes.
Well, how much time? It probably won't be able to wrap up today. I mean, I can get started and we can see how it goes. I mean, just initially, wow, this $1,000 a week in sales, but she's going to be paying her mom $300 a week in child care. And she just got all of these new mowers and
just a second. So you're talking, you're not asking questions. I was just trying to get a sense of how long we need. Let me ask my staff, April or Hannah, do either of you need a break at this point?
Exchange.
It has to be done today.
No, I'm fine right now.
I'm fine as well.
Okay. We'll give it a shot, Mr. Bernardin. Go ahead.
Yeah, given what everything that has just had, I'm definitely going to have even more questions that I'd like to collect myself and adjourn, and we'd finish up tomorrow then.
We have absolutely no time tomorrow. I didn't schedule this for tomorrow.
Well, then what if we run long? I know Ginger had, a full day. I've only got an hour until left on the time. To answer your time question, do I think that there's enough time for me to answer all my questions? No.
Okay.
How about we start and see where we go? Because maybe the questions won't be relevant.
How about you shut up?
That's possible. Just give me a moment while I think about if I want to figure out where we could fit you in.
Well, I'm leaving for Europe and won't be back until May 10th.
When are you
Maybe
leaving?
we could take a 5-minute break and try and figure out a timing.
Attorney Murray, when are you leaving?
So I'm out the rest of so I'm not available other than tomorrow. The 24th, 25th, and 26th, I'm at WIPCOD as a board member. And then the 27th, I leave and I won't be back until May 10th.
I have a question.
Excuse me,
Your Honor. I mean, is there anything that you don't, he had an hour last time you asked him questions to get points across and that would help you. I don't know if there's anything what more can be said about all of this that to drag it out another, for me to start my company and to move on and to do this needs to stop. Like he's dragged this out. When I filed, he threw the papers
for rebuttal. I need to be able to defend myself. You've been attacking me for 2 years.
That's true, guys. That's facts.
Okay. He does have due process rights that I have to afford him certain opportunities. And I do agree there are times in the prior days and even today where things could have been shortened up. I think that certainly, Mr. Bernardin, your refusal to answer directly is probably the main reason for that. But I don't think that's the only reason. And
Definitely
I do think
not.
things could have been shortened up through some of the other questions, perhaps. So I can't say that it's 100% your fault that we're out of time, Mr. Bernardin. I'm going to give you at least some time. I'm not going to give you unlimited time. Giving you about an hour today is not a tremendous amount of time. I will also say I'm not opposed to granting you a judgment effective today, but then taking under advisement the issues that I'm still taking testimony on. In other words, I'm not actually going to grant you anything other than a judgment today, meaning you'll be divorced, but I'll still have to resolve. And that would have happened anyway, probably, because I most likely would have had to work with the numbers and put together my decision. So it's not unlike what would otherwise happen. So what I want to do is try to find when we would put you back on. And then I'm going to ask Mr. Bernardin if it's helpful to just jump in today. I do like to use every minute of court time we have, so I wouldn't mind using another 45 minutes to an hour today. But if he tells me it'll be much more effective to let him put all his thoughts together and organize them, and then he'll ask much more efficient questions, I might be open to just having you pick up next time, Mr. Bernardin, but I'm going to hold you to that promise if that's what we do. So let me
the goal would be to collect my thoughts based on the notes that I've taken through the day.
Your Honor, may I be heard?
I'm sorry.
No,
what did
shut
you
up.
say, Mr. Bernardin?
I said, like you said, the goal is to be collected so that I can formulate proper questions based on the notes of today's hearing. Questions that I have are based on the notes from today, and now it's just
I understand.
hodgepodge of notes.
Attorney Murray, what were you going to say?
It seems to me that based on the objections that have been offered by Mr. Bernardin, that for the most part, what he wants to be heard on is his argument. And one of the things the court can do is allow for argument in writing, which would allow Mr. Bernardin to pull all his thoughts together and present his closing argument in writing, and we can do the same. And so then really we're focused on just the questions, maybe take a 5 or 10 minute break and go until 4:15, 4:30 with any questions. But what we've seen from the concerns that Mr. Bernardin has vocalized repeatedly today have always been met with the conclusion by the court that it's really about the argument he wishes to make. And so that wouldn't need Ms. Bernardin to be under oath, but rather Mr. Bernardin can take how many of our pages he would like with days of time to reduce that to writing as his closing argument.
These are direct questions that I have for Shannon, not necessarily just rebuttal, but direct questions I have regarding her marital spending.
Which is your right.
I know that you have said many times that mine was reckless and excessive, but that's exactly the opposite.
Yes, it was.
Mine, I've been working the whole time. Anything that I spend is for the company and on the company. Anything that she spends is also on the company too, but I don't want to say is reckless, but she has a lot of spending to answer for too. And I've got a lot of questions regarding that.
The representation I have is that he has questions on facts, and I'm going to give him a chance. I'll certainly allow objections if we're getting an argument, and I'm going to hold you to that. We're not arguing, but if you want to ask questions, you can. Looking ahead, I do have a couple hours in the morning of May 14th that I could put you back on if that works.
What day of the week is that?
A Tuesday.
Okay, sounds good.
Attorney Murray, how's that looking for you?
I'm looking. I think I have too many screens open. Everything's going slow. Oh, May 14th is very good for me.
Ms. Bernardin?
Hmm?
I'm sorry, did you say yes?
Sure.
All right, we'll put aside a couple of hours starting at 8:30 that morning for the sole purpose, Mr. Bernardin, of you to cross-examine Ms. Bernardin with questions on facts. And then if you have any rebuttal testimony to share with me based on her testimony, I'll give you a chance to do that as well. We're not getting into any other witnesses. We're not reopening any other testimony. Attorney Murray, I'm going to give you some opportunity for rebuttal, but we're going to try to limit that because I think you were fairly comprehensive today. So we'll do that. Mr. Bernardin, we do have some time today if you want to get started, if you have some initial thoughts.
Yes, please.
Unless you truly feel like it's just going to be kind of scattershot. And if I give you a chance to put more organized thoughts together, that would be better.
Yeah, it sounds like this date we have is perfect to continue the trial.
I would prefer to continue now. We have time set aside. We're here.
Sir, do you have any thoughts together that you could ask?
Like you said, I'd prefer the opportunity that you just gave me to recollect, and we'll reconvene on May 14th.
I need to step in, Your Honor. We were scheduled for a 3-day trial. And so I didn't have to work with Shannon since the last time we were in front of you because I had already prepared her for questions back then. And so Mr. Bernardin should have been prepared for cross-examining her back then. And certainly he should have been prepared.
Now we've run out of time.
I'm not done. And certainly he should have been prepared for asking some questions today. So I find it completely disingenuous to suggest to you today that he didn't think to prepare any questions of Ms. Bernardin today. This is what I'm talking about with delays and expense. And when could we have been done but for all of the statements and interruptions that he was repeatedly told not to engage in?
All right. I think we have a good record of that. Mr. Bernardin, I'm going to have you at least use up the next 15 to 30 minutes to try asking some questions. Then I'm going to give my rulings. Granting the judgment of divorce, they'll be pretty generic, but I want to make sure we have time so I can give that divorce to both of you so you're at least not married anymore.
Happy to oblige.
Go ahead. Ask some questions.
Sure. Let me find Shannon, there she is.
It's showtime.
How long has your mother been living with us, with you?
Since you left the 15th of July, if you'd like me to answer, please let me. The 15th of July in 2022, when you left without notice, took the van, and I had to figure out how.
That was the date? Was July? That was the date you're looking for?
Ms. Bernadette, you're getting into the same habit as Mr. Bernadette. If you just answer the question with the date.
Okay.
July 15th, 2022.
Okay, got it. But she wasn't living there for the 5 years prior to that you said that she's been providing childcare 5 days a week? Where she wasn't living there then?
She would come in and stay with us for the 3 days she was here, and she would go back home. She had a house.
Okay, and what 3 days a week were those?
It usually was Tuesday, Wednesday, Thursday, but it depended on the range. She would, or if we had something going on, she was willing to accommodate for us.
Okay, so and as an employee, would you consider her a reliable employee?
Yes.
Okay, even though we had to purchase vehicles because of her irreliability in the middle of winter, how many times did she not show up for us on a winter snowstorm?
Objection, relevance.
How many questions? How many times?
Objection, relevance.
No. Yeah, what is the relevance of if she wasn't showing up or not?
Okay, well, the person that's trying to buy my house has been living in my house for the last 6 years. So the relevance is that Mary Lurvey, the same person that's been watching my children, has been living in my house for the last 5 years, and now you're awarding her my children in my house. The relevance is that she was our paid employee and our only paid employee. She was on the payroll.
Ms. Bernadette, was your mother on business payroll?
No, she never got a 1099.
And was she employed as some kind of nanny directly by the two of you?
She when she left her job in Honor, she was watching Charlie, and then when Andy was born, Andy, 3 days a week.
Did we keep a log?
No, I had asked, was she paid as some kind of a nanny or other employee by you and Mr. Bernadette?
She was paid with a cash check, yes.
And was it reported for tax purposes or just cash?
She wasn't paid enough to.
It was a company check every week, every month, and every week, wasn't it? We kept a log of all of her hours. We paid her tens of thousands of dollars every year. Bought her vehicles.
Sir, ask a question and then let her answer it, okay?
Okay, the question to you is, of the tens of thousands of dollars that we paid your mother every single year in childcare.
Objection, Your Honor, to the form of question. He's trying to get in argument through a question. Facts not in evidence in his statement.
We're talking about
on cross to ask some stuff. So, ma'am, did you, first of all, it's a compound question is the biggest problem I have with it, Mr. Bernadette. You have to ask one question at a time. Ms. Bernadette, do you agree that you paid tens of thousands of dollars to your mother over the course of the marriage for childcare?
It was $300 a week. I don't think ever got a 1099. So if you have to, as an employee, as an employer, give a 1099.
Was she paid on checks written from the Mad City Lawn bank account as far as you're aware?
Yes. But she claimed and paid her own taxes on that.
Right. And in order for her to avoid paying taxes, she wouldn't allow us to give her a 1099. Is that right, Mrs. Bernadette?
No.
So then why wasn't she paying taxes on all of her earnings?
Objection to facts not in evidence. Objection to the form of the question, and objection to relevance.
It's really not relevant whether or not Miss Bernadette's mom was paying taxes, nor do I know if she would have any.
That she was funneling all the money out of our account. All of the money from Mad City was going to Shannon's mother. And all of the checks prove it.
You can ask questions. You do not get to argue right now.
Okay, so I'd like to recollect my thoughts then for the 14th so that I don't argue. I don't want to sound like I'm arguing, but I do have some points to make that are valid.
Then
Ask
ask
the
the
question.
questions that get to those points,
Okay, so
please.
I did ask the question. So do you or do you not agree that all of the facts show that your mother was paid tens of thousands of dollars every year in childcare for the last at least 5 years? Correct?
No,
Okay, all the facts show otherwise, and you're under oath, Mrs. Bernardin.
what facts? And no.
Yeah,
Sir,
all the they were
sir,
checks. We wrote her
Mr.
check.
Bernardin,
You can look at the
you have, Mr. Bernardin, listen for a second. That would be a valid point if you had a check marked as an exhibit to present to her and ask her questions about. When you just refer to things that you
That's
say
all the
exist in the
checking account
world, that
statements.
isn't helpful to me. Because
All the
it's not in
statements
front of
are
me.
there. All the statements are there. They have all the statements for the last several years.
Then point to it. Which exhibit was it, sir?
It's the exhibit that's marked Fortify Bank statements that show
Okay.
all the checks to Mary Lurvey. And
Do you know
Shannon
what-
even has you can go over to the office. You can look, we documented every last penny that we paid to Mary Lurvey. And as a matter of fact, it was a business expense, every penny that we paid to Mary Lurvey, because it allowed Shannon to work more. So absolutely, every penny paid to Mary Lurvey was a business expense, and we just documented all the tax. So it's in the tax.
Let's ask more questions. Do you have any fact questions to ask Ms. Bernardin?
Yes. About the, definitely we can stay on that same topic and the same subject.
Great. Ask a question.
How many hours a week if you weren't, so are you saying you weren't working at all then if your mother wasn't there helping? Or when were you working then, Shannon? Are you claiming?
So I did 100% of the housework and the care of the girls, as well as I would go over in the office while I was caring for the girls and do care there. Take
Okay, so
deposits
you
to
would
the.
do office work too, then is what you're saying.
Yes or no, ma'am?
Oh, I was still answering, but
Are you
okay.
doing
Yes,
office
I did.
work? Yes, then? Okay. And so also earlier today, I'll get back to it on the 14th, but earlier today, you said you categorized all of the business expenses yourself. You were talked about this deep categorization that you would always do, and then I would just deliver them to the tax preparer. You call them the accountant, but it's just a tax preparer. We never had an accountant for the business, correct?
I would put them on the sheet. You would then go ahead and put them in the categories. And I have the packet that they.
Correct. Yes or no? Did the business ever have an accountant?
No.
Okay, so the accountant that we're talking about is only a tax preparer, somebody that prepares tax, not somebody
Correct.
that's like diving into your business, correct?
As
Right.
as
Yes or no?
seen
Okay,
in
got it.
our.
So when you would categorize them all into different categories, and then you would hand them off to me to give to the tax accountant, you're saying that all of those numbers all of a sudden were different after you did all the categorizing and all the putting in all the categories. Those numbers were somehow different between you handing them to me and me handing them to the tax preparer. Somehow those numbers got muddled. That's what I was trying to gather what you said
Yes.
earlier today. Is that correct?
Yes.
Okay, so the numbers that you handed me are different than what you actually see on your text.
You can see what
correct,
I've
you're trying to
written?
say? Yes or no?
Yes.
Okay, got it. I'm definitely coming back to the tax question because I have more questions, about
Ask
that.
them.
Well, just one smidge is marital waste. You keep talking about this marital waste, but the marital waste that you attribute to some $90-some thousand is actually home repairs, and you rewarded her the home. So all that marital waste is literally concrete that's in her driveway. And addition,
So you're arguing. If you want to ask a question that she could answer with facts, go ahead, but don't argue.
Again, that's something that from today that I would formulate into a question for our 14th visit. So it's
Well, sir, did you prepare any questions to ask? Sir, you knew that you would get a chance to cross her.
Oh yeah, but I didn't know that I was going to have to rebuttal $95,000 in marital waste. That's
okay,
new to
sir.
me. I never heard
But you
of
could
that.
wait and ask all those next time. Did you prepare any questions to ask her for today
Oh yeah, a
regardless
lot
of
about her
the
mother
testimony.
that we were just talking about. Definitely about her mother. And now she's saying that her mother only started in helping with us. I mean, she said she borrowed $175,000 from her mother, but she talks about my wasteful spending or marital spending. I guess my question for you is, where is this $175,000 that you spent? Apparently, that seems awfully wasteful. What did you spend $175,000 on?
Attorney fees, vehicles,
Attorney fees, got it.
mowers.
Okay, I'm running out of time. I only have a little bit of time. One other thing.
Sir,
that
if you wanted to answer the question, you got to let her answer. You can't just interrupt her as soon as she starts
more than
answering.
that. I know she had said she bought a couple vehicles. She said she bought a vehicle, a mower. So with all of that money
do
that
you
you
want
spent,
her to
you
answer
buy
the
all of the things.
Mr.
necessary-
Bernadette?
Oh,
Do
yes,
you want
sorry.
her to answer the question or not? You asked an
Yes.
open-ended question and then you interrupted her as soon as she started explaining it.
Got it. So the question is, of the $175,000 that you had to borrow, you feel that you can adequately run the business right away. I mean, you've been, you got that van immediately since I got back from my trip. You had that black van. So you've been for 2 years now, borrowing money from your family and friends. But yet you're only making $1,000 a week in sales. How are you only making $1,000 a week in sales? So your sales mowing went from $5,000 a week now down to $1,000 a week, and you're now paying $175,000 in debt to your family?
Objection,
Is that
compound
correct?
question and argument.
Oh no, I said, is that correct? Sorry.
Well, it was compound because you put quite a lot into that. So you have to ask it one piece at a time. Imagine wherever there's a comma, you pretty much have to ask a question there.
Right.
All right. So, Miss Bernadette, you got the van from your sister 2 years ago after he took the other van. Is that accurate?
Correct. When he left with the van, I needed something to transport. We started looking and I didn't know when he was going to be back and he put a steering wheel lock on it. So yes, I needed something to transport the
Objection.
girls.
No, see, this is what I'm talking about. The van was there when I got back. So she had her own vehicle to drive and I had the van. So I didn't
Objection,
want
Your
her steering
Honor.
the van.
He is not asking
Lying.
questions.
She's not telling the
Sir,
truth.
You
Objection.
don't get
You're
to
on your
argue
own.
with her, and we can't all talk at once, or my court reporter can't write anything down. So you don't get to argue. You don't get to call her a liar. You get to ask a question.
Okay. The question is who owns the van?
Sierra.
Who's it titled to?
Sierra.
No, the red van is titled in the name of Mad City Lawn and Snow, correct?
Not anymore. It's titled to Matt Wingrove.
Who, at the time we're talking about 2 years ago, this is an asset that is titled in the name of Mad City Lawn and Snow, correct?
Yes.
Okay,
The
and
red
you
van
have
was in Mad
vehicles
City Lawn
titled
and
in your
Snow.
own name. You have vehicles titled in your own name, correct?
I have one truck, but it does not have a rear seat for the girls.
Sorry, if you cannot talk over one another, it's really hard for me to take down two people at once.
Understood.
I can't talk. Never mind.
Okay, so I got the answer to that question. She does have vehicles titled in her name. This one we bought and purchased for the company for company purchases and for company purposes. And so the question to you is, why do you feel that this was a personal asset of yours when the kids had their own vehicle to be hauled around in? Why was this a personal asset of yours that you had said the kids are always using this van? You know, that's where their car seats are when we had 5 car seats. So how is Mad City Lawn and Snow's estimate van your personal vehicle somehow? That's my question.
Okay, that was the only vehicle that the girls rode in. The other vehicles don't have car
What about
seats
the
in
one
them
that we
and don't
bought
have
for your,
extended
what about the
cabs.
one that we bought for the nanny? We bought your mother a $6,000 vehicle to haul the kids around every single day because that's with car seats
Sir,
in it.
what vehicle is that? Be specific. So what vehicle are you saying you bought?
We bought her mother a $6,000 Buick because she's going to be watching our kids. And we needed to know that She's
So
got a
let's,
reliable
yeah, that's what I'm
wage.
saying. I'm asking you to be specific. So Ms. Bernadette, do you agree that a $6,000 Buick was purchased for your mother to use?
No.
It was a company fund checking. We literally paid a check. Came out of the company's checking.
Sir, you're arguing again. So we asked the question. She said no. Do you have another question?
I'm sorry. She said no to what?
Said no, you didn't
it's not
purchase a
arguable.
Buick.
We bought her the vehicle. It's been there for 5 years. You can't argue the vehicle's existence. She's the nanny. She takes care of the kids. That's the nanny vehicle. We paid $6,000.
I hate to object. Mr. Bernardin wants to make his argument, and that's fine, but not today.
Yeah, I agree. Mr. Bernardin, I told you,
Okay.
you can ask
I
questions. You
understand.
can't argue. One more time and
He's
we're
just
done.
wasting time, and he's doing
No,
it
I'm not trying to
intentionally.
waste time. I'm trying to effectively defend myself.
Then
Real
ask your
quick.
questions. I told you, if you don't agree with what she says, then you're supposed to prove to me why she's lying with evidence or when you have your chance for rebuttal later. You don't
That's
get
what
to
I'm
sit
doing.
here
Okay.
and say, well, she's a liar, she's lying. You don't get to do that.
Right. Okay. So, Shannon, would you consider the $25,000 patio project that we upgraded the property with? Would you consider that as marital waste? Is that what you're considering marital waste? Yes or no?
Well, if I had to say yes or no, I'd say yes, that's marital waste. It's not complete. And Earthscapes won't get back to me.
Okay.
The
reason
project
it's not,
isn't done.
but the reason it's not complete is because I'm down here, and the only thing that's not
Objection, Your
complete about
Honor.
it is
He
a little bit of
arguing-
gravel around the
he's
edge.
make- Objection. This
Mr.
is not a-
Bernardin, if you want to ask what's incomplete about it, you could ask that, but let's be specific.
Okay, so the project that we invested $25,000 in, that's maybe
Objection, Your
99%
Honor.
done.
Attorney
Do
Ray,
you
let him
think
ask
it's
the full question
complete
and then
or
you
not?
can object, okay?
Okay.
What's your
Do
full
you
question?
think that project that's 99% complete would be considered, the one that we're talking about, would be considered on the marital waste spectrum in your world? Yes or no?
She already answered
Yes.
that. So
Okay, got it. And what about replacing the concrete driveway, the $40,000 that we spent on replacing the driveway? Or no, I don't want to misquote the numbers. We have exact numbers. There's receipt.
Yeah.
So do you believe that driveway is what I'm talking about? I don't want to misquote the number. Do you think that that is also considered marital waste in your?
No,
Replacing-
that is completed.
But it's not though. It's only 99% complete. It still
Your
needs the
Honor,
same
I'm going to
gravel.
object to this line of questioning. First of all, it's not even their property. It's on a land contract.
No, it is
Second
our
of all,
property. Okay,
I'm-
that leaves my next question. We do own the
No.
property.
Second
My
of all,
question for you-
Mr. Bernardin is assuming facts, not in evidence, when he's asking questions and then demanding that my client say yes or no. It is not okay to say a fact A, B, and C, and so yes or no, when there is no fact A, B, or C in the record. We have not heard anything about a cost for a patio. We've not heard anything about a cost for.
That's the marital spending that you're
I've heard
talking
enough.
about.
He can
I
ask
just have
about
one
those
more
things.
quick
That is
thing
one
about
way.
the
No,
title of
stop,
property.
sir. When I'm
Sorry,
talking,
I
you just
didn't
got to
mean to-
stop.
I can't hear
He
you.
can ask questions whether or not you chose to. I'm not limiting him only to what you had your client testify about. So he can ask about facts, not in evidence. That's fine. And if he wants to say something about on cross, it's totally allowed to say, isn't this the case, and give some specific fact. I'm going to allow that. I'm not going to take argument on whether or not and what effect I should give to the land contract. I'm not going to stop him from asking about it just because of the argument your client wants to take on that. Mr. Bernardin, what do you say is incomplete about this driveway?
Okay, it just needs a little bit of gravel around the edges. The same thing as the patio.
Okay, Ms. Bernardin, do you agree that the driveway still needs gravel placed around its edges?
The driveway was done by a separate company from the patio. So the driveway is mostly complete. It just needs the dirt and a drain on the side. The patio and rock wall are nowhere near done. And the work that was done, I have put out to Earthscapes, but because Gabe did work with them, I have not gotten a response as far as because we owed them money. He owed them money for sidewalk stuff. So there was $17,000 paid for the work to be done here, and it isn't done. So we prepaid for this stuff, but then he had them do winter work. So we owed them money. Or well, he owed them money because I didn't.
No, it's done. They just tore up a little bit of the grass. So the grass needs to be resodded, but that wasn't part of their
Sir,
bid.
if you
Their
want
bid
to
was to
testify
support
in rebuttal, you can do it later. You don't get to disagree and argue with her right now.
Okay, got it. So the only question I just have then is just about title. Do you remember when you took title of the property as owner? Do you remember the date of that? Can you tell me the date?
What property?
We own 3 properties. We were at closing. The company owns 3 properties. We were at closing, and Mad City Lawn and Snow took title of these 3 properties. We are owners of these 3 properties. We can sell them right now, and we can take $300,000. Yep.
We have a land contract.
Yeah, land contract. He's just the banker.
Sir,
Land contract is not rental.
No, stop arguing.
We own it. We own it.
Mr. Bernardin, I'm inclined to just not let you have any more time and to cancel our last day because you're just wasting time arguing. I understand how land contracts work. I have foreclosed land contracts. I've presided over land contracts. I know what they are. I don't need to hear the two of you argue with each other about it. Do you have fact questions?
Judge knows all.
Yeah, the fact questions, I have, do revolve around the land contract. And I don't want them to come across as argumentative or
just ask them, and I'll tell you if it's argumentative, and then you need to rephrase it. But try to just ask an actual question, one question at a time.
Okay, what's your idea of what a land contract is, Shannon? Are we growing equity in the property? Yes or no? Does your monthly payment grow equity? Yes or no?
If you miss the payment, they can take the
So for
property.
the
And
last
so
7
you
years,
don't.
have we been growing equity? Before your mother bought it from me when I left, did you pay equity and receive equity on every one of your payments for the last 7 years? All of the money you said from our sold house went into that as a down payment. So how much was the down payment on our property?
$30,000 from the sale of my home.
Okay, but again, we agreed that I lived there for 7 years before. But okay, so the sale of my home went into your home, and then your home rolled into mine. And
Mr.
my dad, remember,
Bernardin,
gave us
that
money.
would be a question to ask. So ask that. Miss Bernardin, did he contribute any money from selling his own home into your home or the mortgage for it?
I'm sorry, can you repeat the question?
Did Mr. Bernardin contribute any money into the value of your home after selling his own home, whether by paying toward your mortgage or otherwise investing in that home?
Mortgage came from my property. I paid for him to get the quitclaim deed so he could sell his house. That was a check from me so he could sell his house. So
I don't know what that even means, but when he sold his house, did he have equity that he put into your house? Yes or no?
he hasn't improved any documents. No. I don't have any documents and he hasn't proved any. So no, I don't know.
And what does that matter if he has documents? I'm asking, did he contribute any money at that time when he sold his house?
I bought my house in 2010. We got married in 2012. So he didn't live with me for 7 years. He got divorced in 2011 from his ex-wife. They had a home. They got a quitclaim deed where I helped pay the taxes so he could get the quitclaim deed to get her off, and he took possession of that home. He still had that home, and when he sold it, he had it rented out. So he was still paying for his house while I was paying for my house. So if he took from his property, I don't remember taking that he put a ton of money into my property. No.
And you keep calling it your house, but do you agree you owned it for some years after the two of you were married?
I owned it.
The two of you lived there after you were married.
When did he sell his house?
Ms. Bernadine, I don't think you want to go down the road of arguing with me at this point. I've had enough of Mr. Bernadine's arguing. I'm asking you questions. I'm the judge deciding your case. So you may want to just take a step back, take a breath, and answer my question, okay?
Okay.
He lived at the house while the two of you were married that you had brought into the marriage, correct?
Correct.
Are you saying he never contributed anything to that house while he lived there while you were married?
He did, but he also had his house that he was paying his mortgage for. And I don't know exactly when that sold. So there was still
2011.
Mr. Bernadine, I'm not inviting you to interrupt.
Sorry.
All right. So he had his own house for some years while the two of you were married as well.
correct.
Yes.
And
He was renting it out and making money, but also paying for it.
but the rent didn't cover the entire mortgage.
Okay. All right. And you aren't aware when, you don't recall when he sold it or what he got out of it, if anything?
He refinanced it in 2012, but I don't know when it sold because the property has been demolished and now there's condominiums. So I couldn't find records to try and refresh. And because
sold
it wasn't my,
Mr. Bernadette,
I-
stop.
I apologize. I sold it in 12.
Okay. Mr. Bernadette, any other questions?
Yeah. I have a lot of questions. Would you like me to hold them off for the 14th? Just
I'm
real quick.
inclined to just cancel the 14th because you've wasted the half hour I've given you today.
No, I apologize. I'm so sorry. I didn't waste any. I'm just trying to get to the bottom of these questions. I have so many more. Please allow me the opportunity that you just said.
Then ask a couple. Stop arguing, stop interrupting, ask a question.
No, I was, and I have been. So back to the title of the property. So all of this money that we've been putting into this property, was it your impression, Shannon, that you're putting this money into somebody else's property and you're improving somebody else's property? Or was this improvements to like your own equity because you own it?
well, it's just like the trucks. You pay the trucks. If you stop paying them, the bank takes them. You don't get that money back. So as long as you keep paying them, yes, we're building equity if we keep paying and whatever the market value is. I don't.
Right. And we were all up to date on payments before your mother took over the payments. And we never lost any payments, right? So we still own the
That
property.
was a question, so stop there and let her answer it. In other words, you were current on your land contract up until he left, correct?
The mortgage bounced when he shipped the trailer back. There wasn't enough
That was
money
2
in
months
there.
later.
And Ms. Brennan, you agree that if you keep paying your land contract, eventually you will get all that equity, correct?
If it keeps getting paid, correct.
And that theoretically, if your vendor was willing to do so, you could find somebody else to buy it or buy your interest under the land contract and assign it to another person, correct?
Correct. The value is, that's where the sticking point is, the value. And our property is unique. And so it's hard to find a comp, but
Is that why you had to go with the land contract?
we couldn't get a traditional loan for this. We couldn't afford.
Okay, because of your own finances, not because of the unique nature of the property?
The market, what we needed, the size of the loan,
Okay.
correct.
Mr. Bernadette, go ahead.
Okay, yeah. So you agree, so she agreed that it's all equity. Tell me more about this non-complete clause. You said early in the very beginning, Fremgen, you said he wouldn't allow for splitting the business. But yet at the same time you said he was splitting the business. I'll reformulate that question. Let me ask you this. How much money was in the account when Dr. Goodnature's $6,000 was removed from our only checking account in our world? It was removed from the business checking account, $6,000 to Dr. Goodnature. It was November of 22. How much money was in the account when that happened?
I'd have to look at the bank statements.
Let me refresh your memory. So the bank statements show that we had $6,500 and Dr. Goodnature took $6,000 of our $6,000 in plow prepayments that winter that we got from Yahara River Learning Center. So the question is to you is, did you know that you were spending Yahara River Learning Center's plow prepayments on Dr. Goodnature's report and for this divorce with company funds? Did you know that you were doing that when you did it?
For anybody who doesn't know what the Dr. Goodnature report is, so what happened is this lawyer sent him a list of questions about finances and things like that he was supposed to answer. And he didn't answer any of them. So they had a hearing and she tried to ask them, but he didn't answer any of them. So they had to go and they had to get an expert to figure out his finances since he wouldn't answer any of the questions. And then they had to pay for this expert. So that's the money that he's talking about here.
Yeah, like I don't even know where to start with my objection. What? There's like no facts and evidence to support anything he just said about what money was being used for Dr. Goodnature. Like, and what's the relevance? But also, where is he coming up with this? There's like no foundation for what he's saying, and then asking my client to agree or disagree.
Or do you have an exhibit you could point her to?
Yeah, she has the bank statements from Fortify. You can just pull up November and you'll see the total that was in the bank from plow print. You can see the deposit and you can also see Dr. Goodnature's withdrawal of all of our money. And that was at the very beginning of the divorce. And I just wanted to know if she was aware of how much was in that checking account when she paid $6,000 to Dr. Goodnature. She drained the entire checking account. I wasn't sure if she was aware of that.
And why is that important? What does that have to do with any issue I'm deciding?
I guess it started with her, the day started, how Ginger started the day with the non-compete clause, and it went with Fremgen. And so I just kind of wanted to start at the beginning of the divorce. And this is a financial conversation. So I wanted to start the financials. She had talked about all of these prepayments that, were into Shannon's account. But I never had a separate account that took any Mad City prepayments or anything like that. All the prepayments were in Shannon's account, and the records show this. So I guess I wasn't sure, and I was just trying to formulate that into a proper question for her.
All right, here's what we're going to do. I'm going to make my findings to grant the judgment today. Mr. Bernardin, I'm going to give you the chance to organize thoughts. I'm going to instruct you to write them down, write your questions down. I'm not going to make you show them to me unless we really start, if it's clear you don't have questions thought out. On the 14th, I may tell you have to hold it up and show me where you wrote these down. You do need to organize your thoughts. You should have done some more of that today. I get that there's some of what you heard today probably took you off guard, but you should have at least been somewhat prepared to ask some questions because you knew certain topics Ms. Bernardin would talk about or that you'd want to ask her about. And I
kind of thought it was a 2-day trial.
No, sir, I don't need.
Oh, sorry.
So I'm going to give you that chance. If we get into it on the 14th and it's clear that you haven't prepared at all, I'm just going to cancel. I'm just going to consider your right waived. We're going to end the hearing early. I'm probably going to award some attorney fees for the wasted time that day off the top. And then I'll get into the other arguments about whether I should award additional attorney fees or not. what I want you to do is, while you're preparing your thoughts, when you talk about a document existing in the record that shows what you're saying, like a bank record, what you're using these next few weeks for is find the document, write down the exhibit number and page number, and be prepared to point Ms. Bernadette directly to exhibit blank, page number blank. And if you're capable, I know you're on a phone, so it may be impossible to share screen, but if you at least say an exhibit number and page, I'll share my screen if you can give me exhibit number and page, and Ms. Bernadette can look at it and you can look at it. But you have to think through and prepare things like that. So it's not just, oh, just look at these bank records. No, tell me, what exhibit are you saying they're in and what page is it on that you want to show a line item? Do you understand? You're going to have to unmute, sir. I think you muted yourself.
Yes.
That's what I expect for next time. I also want you to think through whether you want to put closing arguments in writing, or if you want to use some of that time on the 14th just to tell me your argument orally. I don't mind either way. I think either one is useful and effective. We're not going to have any more time other than what I give on the 14th. If I feel like it's being wasted, I'm just going to call an end to the trial and we'll proceed directly to argument. Any questions, Mr. Bernadette? You muted yourself again.
No.
All right, Attorney Murray, any questions about what's happening on the 14th?
2 questions. 1, so I think what ultimately I heard is I should be prepared with a closing argument for the 14th.
I'm open if both of sides want in writing, but I think it might be more efficient if it's just a oral closing.
Okay. And then 2, I was in the predicament where a judgment was granted before the evidence was completed and the husband died before we made it back. And Attorney Sipsma challenged the divorce and we prevailed as long as the evidence is in. And so what I think I heard you say is we're not bringing in any new exhibits. We're not bringing in any new witnesses, but Mr. Bernadette has the right to question Ms. Bernadette about the things she testified to or things that she might not have testified to, but we're working with the evidence that's been presented. I just want to make sure that we don't get ourselves into a predicament where there would be a problem, but I don't think we will be because all exhibits are in, all witnesses have gone. We're doing a final cross-examination and maybe some final rebuttal on the exhibits or prior testimony that's already been captured, correct?
That is true. The only reason that that's true is because Mr. Bernadette doesn't get to introduce any additional exhibits because of his failures to provide exhibits ahead of time. There will be new evidence, whatever comes in through the additional cross and rebuttal. In other words, the testimony may be new. I imagine it'll be new. I guess I was offering to grant the divorce today for the benefit of your client.
Yes, she wants it desperately.
About it. Unfortunately, that is always a possibility. If somebody dies, that I lose jurisdiction and I'm not making any final decisions without all the evidence as to the property, the support arguments, or the waste arguments. So I'm leaving essentially all the issues open except for whether they should get a divorce or not.
Right, so we've got the kids' issues resolved. There is a current child support order. The issue really is the finances. And we have 2 relatively healthy people. I know my client wants the divorce. I know that she wants it desperately. So I'm not going to get in the way of that.
Okay. I'm going to, at Ms. Bernadette's request, grant a judgment of divorce effective today. I'll find that jurisdiction does exist and venue is appropriate here in Dane County. Both parties did live here when filed, and I've heard that the marriage is irretrievably broken. The testimony certainly confirmed that, so I can easily find this marriage is irretrievably broken with no reasonable chance of reconciliation. I've made all the findings previously that I need to related to the children, and I issued a default order on custody and placement. That is still part of my judgment of divorce. We'll reincorporate it into the final judgment, but it's a effective final order as of the date I originally issued it. On the property division, I am going to make one order in the hopes that it helps Miss Bernadette. I'm awarding you all rights and interest in the Mad City business and the customers. I'm reserving the decision on some of the equipment because we have some argument about who should get what equipment, and you propose Mr. Bernadette should get some. But I'm awarding you the right to all the customers that you would choose to use. At that point, if you choose not to use all of them, I'll say share with Mr. Bernadette those he does that you are choosing not to service. But you have no obligation beyond that. You don't have to encourage them to go to him. You just have to give them a list of the people you are saying, I'm not going to pick up this customer. And I'm reserving the issue of whether and what value, if any, to give the business, but I am awarding it to you 100%. So if you want to close it, which is what it sounds like, and open your own so it's clean and nice, you can absolutely do that. If you want to try to figure things out and use this actual business and name, that I'm awarding you that right as well. In short, I'm going to ask Attorney Murray just to put a very short piece of paper together saying it's yours to do with as you please, and that any business you open going forward, either of you, would be 100% yours, and your marriage is over, so there'd be no marital property rights to do with it. That way, at least hopefully you can start on your own path with a business and how you want to pursue that. And I think that's everything. Well, I can find as well, you testified you're not currently pregnant, so I can grant the divorce effective right now. The 120 days expired long ago. And again, I'm reserving ruling on those final issues to do with support and the rest of the property division, aside from awarding you the business and the clients and the rights to do with the business. And if you want to put specifically in there, I'm awarding her all rights to retrieve any accounts related to the business, including email or debt or other accounts. I don't know if that'll make any difference to any of these creditors, providers, etc. But if you think it might help, throw a line in like that. If it helps them override their own system and wanting to get verification from emails and phones and other stuff like that, I'm willing to put that in there.
So I have a question.
I'm also granting you your right to go back to your previous name, Lurvey, L-U-R-V-E-Y. Anything else, Attorney Murray, you think I should find today or put on the record? And you said you have a question.
I do have a question. So I heard that you're leaving some of the things about the business out there. My concern, of course, is the unknown amount of debt that may be owed to customers. Like, are you dealing with that today, or is that part of what will come out of the arguments and or whatever else happens on 314? We know that there's that levy. We know that there's the $8,000+ debt to the Department of Revenue. We know that there's at least $15,000 of prepayments for fertilizer. Are you saddling Shannon with those debts today?
Frankly, I don't know what the legalities of the parties having a incorporated business, whether or not I can just pull debts out from it. I mean, I think the testimony made it pretty clear to me. Any creditor would have quite a strong argument that this wasn't even a real business entity and that they could go after either or both parties. But I don't know that I can say I'm taking a debt out of the business. I could say it, but I don't know that that would have any impact on a creditor. So I'm saying I'm awarding her all rights to do with the business and the right, if she wants, of course, she can do whatever she wants now because I'm divorcing her, so she can make her own business. I'm making clear if she opens a new business, that's post-divorce, so it's hers, it's individual property. It was never marital property. That's the benefit of the divorce judgment today. If she wants to leave it so that I maybe assign the business itself and she just gets the customers. I think I could do that. I could say the asset of the business, which is the customers, she can have the right to, and I foreclose Mr. Bernardin of any claim that she's stealing a corporate asset or opportunity or thing like that. I think I could do that. And
I would like the
open-
opportunity to research and
Don't
make
interrupt the
argument,
judge.
no new evidence, but argument about the division of the debt. So if you could leave that open for me to address on the 14th, I'd appreciate that.
Absolutely. I know I can assign it. I'm just not clear how it would look if I have to assign part of the business and keep the debts with it, or if I just account. So I'm holding open the value of the business and everything to do with it.
Yeah, I understand.
Okay.
I will try and have this drafted before we come back before you, so this can be issued. I'll get this out before I leave.
Okay. All right.
But it's effective today, Shannon. The divorce is effective today.
And if you upload something to that effect, I'll sign it. Attorney
Okay.
Murray. All right. Anything else before I let you go, Attorney Murray?
I know those were my 2 questions. Thank you.
Mr. Bernardin? You're muted, sir.
No, sir. Thank you.
All right. Okay. I'll let you all go. I'll see you on the 14th. Have a safe trip, Attorney Murray. I hope it's good.
Thank you.
What time?
We'll start right at 8:30. Oh, or did you need 9? I remember today we did
The
9.
kids,
right?
yeah.
I mean, 8:30 is fine. I can make it work. But
You tell us.
it's-
You got the kids.
I would
so
like
do
it
you
to
wanna-
be 9, Your Honor. That gives her a chance to talk to me before we come in because she's busy getting the kids ready in the morning.
9 a.m. then. We'll send out a notice of hearing. It'll be by Zoom again.
Okay. Thank you.
Thank you.
Of course. Have a good day, everyone.
You too. Bye.
Thank you. Bye.
I don't know if I can handle another day of that attorney. I just don't know if I can handle it. Look, the judge is sleeping. Wake up, judge. Wake up. Boy, that guy. So she gets a little evasive when he starts questioning her because she doesn't want to talk to him. She doesn't want to answer his questions. She doesn't want to give him 1 inch, not an inch. So she doesn't answer him. And the judge, oh yeah, she does. So she's guilty. She's guilty. Carolyn figured it out. I can't believe I didn't. Yep, guilty. Okay, let's get on to Fleischer. Okay, so I didn't see any of this. I edited it without seeing any of it. So hopefully nothing bad happens.
It's not a good morning. No, it most certainly isn't. Let's go through your summary, Mr. Gutierrez.
Sir.
Client was placed on community supervision on 8/3/23. He was referred to IOP SOP on 9/5/23. You were assigned to the SACC caseload on 9/6/23. You were referred to IOP SOP, which is the outpatient treatment programs, intensive outpatient and supportive outpatient treatment. If you failed to complete the DWI intervention program, failed to complete with the rules of his portable alcohol monitoring device, the client has a large amount of skip tests. They were verbally, I'm sorry, am I boring you? Verbally addressed to you by the probation officer on a repeated basis. You have 2 positive UAs for alcohol and THC on 11/23 and 2/24. And now the recommendation is what? That's what we're going to do. I tried to get you to do this on your own. You were unable to do it. Now we're going to do it my way. Goes with you.
Come on up.
You gonna do it? I emailed Dylan. Okay, yeah, you got it.
King Sir Ayibo. Good morning, sir. You are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
On April 15, 2024, in Harris County, officer dispatched to a disturbance call. Officer met with the complainant who was married to the now defendant. The defendant had been drinking in the evening and started an argument with the complainant, and while complainant was sitting in a chair, he pushed the complainant and scratched her arm, causing pain. Officer noted the complainant had a small cut on her arm.
Can you run an NCIC to see what other priors, if anybody?
Yes,
Mr. Kim. Mr. Ayibo, I'm going to find that there's probable cause to go forward with your case. I'm now ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or dope, you will go to jail. You will not get any more PR bonds. Do you understand?
No problem, Judge.
Okay. Do we know if she wants to have contact with him?
No, we haven't had successful contact yet. There was one attempt about a week ago.
Okay. I don't know if she wants to have contact with you. So until I know that she wants to talk to you, I'm ordering you not to have any contact with her. I'm also ordering you not to be in possession of any weapons. It looks like they didn't do a MOAB. So I'm entering in what's called a magistrate's order for emergency protection that identifies Victoria Ayibo as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. You understand? If you violate this court order, the state can and will file a violation of a protective order against you. And that's one of the worst cases that you can pick up. Tell me, what do you do for a living, sir?
Warehouse leader, civil logistics.
How much money do you make a month?
Well, it depends because right now our hours is short now, so we're making 35 hours. So I'm going home with $560 a week.
So you make around, give or take, $2,000 a month.
Yes.
Do you have any children?
No.
You afford a lawyer, sir?
At this time, because
let's do this. Let's do this. I want you to go out there. I want you to start looking. There's a gajillion and one lawyers in Harris County. It's a matter of you getting one, like buying a car. You don't go to a Ferrari dealership when you first start buying a car. Same thing with a lawyer. You go to one, you find one within your price range, negotiate with them. 99% of them will put you on a payment plan if you ask. Negotiate with them. Don't take them at first blush. If they say no, go to the next one. If you have any issue, just come back and talk to me and then we can go further. All right?
My wife, I'm the one who take care of it. She don't want to work. So the bills, I'm the one paying everything. So
for now, until I know that she wants to have contact with you, I just don't want it. I don't want it to happen. I will have them later on reach out to her to see if there's contact. Also, when you have a lawyer, the lawyer can come and approach and then we can talk about modifying the conditions. But I want to know, I want to honor her wishes. That's my first concern. And I don't know what she wants to do with you. Okay. So for now, I'm going to have you go to Victoria. We'll have you sign a reset. After that, I'm going to have you take a seat in the jury box while I get your bond conditions. I'll have you sign it and then you'll be free to go. All right.
Right this
Please.
way. Counsel, do you have an argument? Okay. Next judge, we have page 13, Miller. Come on up.
Wait, Tamika Miller. Ms. Miller, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, ma'am. Okay.
On April 15th, officer flagged down Harris County minor accident inspects parking lot where a motorist flagged down that he was in an accident, stated that the now defendant was the operator and single occupant of the striking vehicle. The defendant was stumbling and unsteady on her feet as she was nearly struck by a reversing vehicle in the parking lot. Officer detected slurred speech, odor of alcohol emitting from her breath. And they found a Tito's vodka bottle, 1.75 liter bottle in the rear passenger seat of the vehicle, and the bottle being about 3/4 empty. The now defendant was asked for her driver's license, and she continued to sway and displayed poor coordination, had delayed reaction response. 6 on HGM, 7 on walk and turn, 3 on one leg stand. DIC was read, but the breath was rejected, and the blood warrant was executed.
Ma'am, I'm going to find that there's probable cause to go forward with your case. I hope that you realize it's elementary not to have alcohol in the car while you're driving, ma'am.
What's in my trunk?
Regardless, just be careful, ma'am. If they allege it, it's a minimum of 5 days in jail. I don't see that they have now. I am ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. You understand?
Okay, I'm sorry. What did you say, sir? I can't hardly hear. Like, seriously.
I'm finding probable cause in your case. I'm ordering you not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or dope, you will go to jail. Do you have a valid Texas driver license? Do you have valid liability insurance in your name? You may continue to drive, but if it becomes suspended, you may not drive. Do you mind running your license, Dave, please?
I only see a state ID and running this.
I see that you do have a lawyer, ma'am. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Dan Simons and he will tell you if and when you have to come back to court. If Dan tells me that he can't get a hold of you because you're playing games, I will issue a warrant for your arrest.
Okay, sir, thank you.
So for now, we'll have you sign a reset, then you'll get with Jeremiah for your bond conditions, and then you're free to go, man.
Right this way. Judge, we have one more.
Okay.
He is a Spanish speaker, so we'll wait on this.
Got it.
I'm sorry, I see one more. Page
Tell me.
24, William.
Her license is eligible, but it doesn't show that it's active. It only has an ID with an expiration date of a decade ago. So if she has one in another state, I don't know, but Texas didn't want anything.
So tell her, just tell her to take a seat when Dan Simons comes, then we'll address it. Because I need to know if she has a license or not.
Oh, okay, so I'll put
Right.
it on. I'm gonna take you to sign. Ms. Williams, come on up.
I'll sign that.
Miller.
No, Dave, we have one more, please.
Oh, there's one.
Yeah.
Oh.
Ma'am, come up. What is your name?
Williams. Williams on page 24. All right, go
And do you have a lawyer?
Paper, I do, yeah. The last
Your
time.
case is nearly 400 days old. You've taken off multiple times. I am not happy with you, ma'am. The next time you skip out on me, I'm going to make your bond so high you're going to flip. Do you understand? Who is your lawyer, ma'am?
Garcia.
Okay. No resets. We figure out today what happens. Take a seat for me in the jury box, ma'am. Greg.
Are you assigned?
Hey, Judge, how are you?
Hey, bud. What's up?
Hey, I just have this case today, so I'm jumping on, but we already took care of my Alexis Kidder, right? Okay. So my other case is Brittany Gillardoni. She is in custody. I don't see that a rip call has been done, but I believe she's on probation. So I don't know.
Greg, what was the last name again?
Gillardoni.
I have a Gilladon.
She's got an alias.
It's Gillardoni.
But yeah, she has an alias of Gilladon as well. It's,
Oh yeah, that's the AK. We have the AK.
So she's on probation for felon in possession, possession less than a gram, and now she's picked up an assault.
yes.
The bond, our bond is set at 2,500. I don't know if she's made bond on the felony cases.
Wait.
Oh, she's got quite the history, man. Tell me, what do you want?
I was just waiting to see what felony's doing. I mean, the rip call hadn't been done, so they haven't made a rec, which I understand, but.
The next setting date for the felony is 2/27 of 24. So that tells me they haven't done anything. She probably hasn't even made it up. Let's see if they've even filed a motion to revoke. It may be just
She attempted once, but she hasn't called back.
Hey, look, they filed a motion to adjudicate in February of this year already once. They had another one in December.
So they haven't filed it yet. The last one was in 2/27 for the last revocation, but her bond is still technically set at 10,000 for the one back in February. So I imagine they're going to do it sometime soon.
Yeah, it's her third time, Greg. So
You want to do like a 2-week reset, Judge?
yeah, I guess we'll do that.
Okay.
We need to probably do conditions though, because I don't know if she's going to get out.
This one,
Because that's a low bond, and if she makes our bond, I might.
then she's had 2 fugitive cases in in this court.
Yeah, do you mind bringing her up, please? So, Dave, let's do PC real quick, huh? When she gets out here.
Yeah, Judge, sorry, I jumped on Zoom because it's my only case today. That and the fugitive.
Get you out of here quick, man.
Yeah, no worries. I'm not, that's why I didn't come down there, so.
While they're getting her, I'll tell you, we had a poll in chat. What color is he going to wear tomorrow? It was either blue, red, green, or a black robe. Just so you know, black robe has got 0 votes, even though he's a judge. So red only got 12% of the votes. Green, 37% of the votes. Blue is a top again. I guess it's a safe bet. You pick blue, it's a safe bet. But we'll see. We'll see what happens.
Hi, come on. Good morning.
I'm here on Mr. Taylor. I believe he's Julius Taylor on the court docket, but his name is actually Carlos. Iron that out yet.
Is he on bond or in jail?
He is in custody, sir. He had a pending misdemeanor case in your court, and he has picked up a new case in addition to a felony. They set a felony bond in Judge Warren's court for $10,000 yesterday, and Mr. Taylor is homeless. He has no money to make any sort of bond whatsoever. So.
But I'm still going to revoke the bond that he's on the B&B.
Understood.
So he picked up another B&B, and then what happened? Did he break into the car and start using credit cards today?
He was in, well, I don't know if you want the state to tell you.
Walking and pulling on door handles, attempting to enter, had multiple credit cards and debit cards and driver's license not belonging to the now defendant on this person. And the complainant, the day before, stated she parked in her vehicle where the defendant went into her wallet and took all her driver's license, all the credit cards, and stole the laptop that was in the vehicle.
Okay, I'm going to end up revoking it, setting it 5,002. And then the felonies are set for, oh my Lord.
20th.
We don't like to do
I assumed it's the same, Your Honor.
You can have whatever you want after 30 days, yeah?
Just a normal reset.
For sure. Yeah, okay, yes, ma'am. Thanks. Okay. Good morning, Ms. Gillardoni.
Yes, sir. Good morning.
How's jail? I guess we're not getting your attention. Come on up to the bar. I guess we're still not getting your attention. So you now stand charged with assault, bodily injury. You're facing a year in jail and or a $4,000 fine.
Counselors, keep it down, please. Yes, sir.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford one will be appointed to you. Just so you know, you're not here alone. Look on the screen up there. That's Greg. He's been appointed to represent you. So you do have a lawyer with you today.
On April 6th, officer replied by the complainant who stated that the now defendant was walking on the north side of the street. The complainant stated that she was walking with a male friend when the now defendant came from behind and began a conversation with the male. Complainant stated she didn't know the defendant, and complainant stated that her male friend left and the defendant turned to complainant and stated, quote, "I'm going to drag you down the street," end quote. They got into a verbal altercation where the defendant grabbed the complainant by the hair, threw her to the ground and drug her on the concrete floor, then stomped on her head once. Complainant stated she felt pain, had a knot and early bruise forming on the left side of her head that the officer was able to observe, and an abrasion to her left knee that was bleeding.
Ma'am, I'm going to find that there's probable cause to go forward with your case. I don't know if you're going to get out, but if you do, I'm ordering you under home confinement. You are not allowed out for any reason. Do you understand? I'm also going to put a GPS monitor so I know where you are at all times. I'm ordering you not to be in possession of weapons and not to have contact with any of the complaining witnesses.
That's all I do for this country. Yes, sir. Thank you. The nation, matter of fact.
You're done.
I appreciate that,
You're
sir.
done.
Thank you.
You're done.
No, it's something. I'm good, Your Honor.
Gilardoni.
You might be on your
Gilardoni with the G. So you want to go ahead and have her evaluated, Greg?
Yeah, I could do that.
Can't hurt.
Let me make a note. I'll do the paperwork tomorrow when I'm down there.
Please.
Yes.
Solamente mire, pues por favor, y le contesta en español nada más.
Or Jason Nunez?
Jason Nunez?
Mr. Nunez, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford a lawyer will be appointed to represent you, sir.
On April 15th,
El 15 de abril,
officers were dispatched to a family violence call.
a un llamado de violencia familiar.
The complainant and the defendant are married and share a child.
Y comparten un hijo.
The defendant slapped the complainant on the right side of her face, causing pain.
Causándole dolor.
When the complainant grabbed the defendant's shirt, the defendant grabbed the complainant's right hand and bit her, causing pain.
Mr. Nunez, I'm going to find that there's probable cause to go forward with your case. Are you a United States citizen?
No.
Are you in this country with or without permission?
Sin permiso. Perdón? Con permiso. With permission.
I don't know if you are or not. You could be the Queen of England. I wouldn't any different. The only thing I'm telling you is that if you go to jail and your papers aren't in order and immigration finds you, they will put a detainer on you. You will remain in custody until immigration is done with you, which is usually about 9 months.
I do show that he was arrested in 2023 for an alien invisibility.
So that was a federal case.
No, it's just that he was, I don't know what the circumstances were, but just that he was arrested due to the alien invisibility part statute, but there was no charge. Just that he was arrested.
You've already had one contact. If you come into this country illegally, it's a minimum of 5 years in federal prison. I would be very careful, Mr. Nunez. Don't violate the conditions I've put on you now. Otherwise, I will put you in jail. And if you're unlucky enough, you're going to be there for an extremely long time. I am now ordering you as a condition of your bond not to have any contact with the complaining witness and not to be in possession of any weapons. Protective order was issued on the 16th of this month. I would get to know it because if you violate that court order, the state can and will file a violation of protective order And that's one of the worst cases you can pick up.
No, esa es una de las peores casos que podría obtener usted.
Do you understand?
Señor.
And don't drive.
Yes, perfect.
How old are you?
¿Qué edad tienes?
33 años.
33 years of age.
What do you do for a living, sir?
¿A qué se dedica? ¿En qué trabaja?
En DIF, hago delivery.
Deliveries. I do deliveries. ¿En qué dijo primero?
Delivery.
Oh, delivery.
You don't drive, do you?
Maneja, ¿no?
Sí, yo tengo
Solo mire el juez, por favor. Yes, I do. I have a
You
license.
don't have a Texas driver license, do you?
¿Está conducido en Texas, no?
Sí.
Yes, I do.
Oh, can you run his license? If you have a license and you can
La
drive,
licencia de Texas.
as long as you have liability insurance.
Tiene seguro básico de automóvil.
I only show a DPS number, but
yeah,
that's not the number I have. And I'm going to run this separately. Give me 1 moment.
What do you do? So how much money do you make a month?
¿Cuánto gana aproximadamente por mes, señor? Solo mira el juez. Procura por mirarlo a él.
Más de 1,200.
Approximately around 1,200.
How many children do you have?
¿Cuántos hijos tiene usted?
2.
2.
You make $1,200 a month or per week?
1,200 por mes o por
Every
semana.
other week. Excuse me. Did you want to apply for an appointed lawyer,
¿Eso
sir?
por un abogado de oficio para que le ayude con este caso?
Sí, free que es gratis. Me puede ayudar.
Yes, free one that can help me.
Don't violate the conditions we put forth. I'm giving you a lawyer. There's no excuse. You violate these conditions, I'm going to light you up.
Okay.
You understand?
¿Usted entiende eso?
Sí.
Yes.
I found out what it was, is we don't have this AKA of Dyson. The way it's spelled in our system is DASON, but this one has a DAISON. That license is valid if that is a true AKA.
Wonderful. Okay. All right. So for now, I'm going to have you fill out an application for a lawyer. Do not leave until you sign our bond conditions, and then we'll have you talk to someone here momentarily, sir.
Y hágase aquí. You want him to go in there?
Well, first to sign a reset, and then we'll have
Un
him.
aplazamiento y después vuelve a esta caja del estrado para llenar el papel.
Melissa, I filed the one on Ayabo. I'm filing the one on this one now. Yep.
That's wonderful. He has a license. Great. Okay. Mr. Johnson. She's going to get evaluated.
You never know.
As a caution. Ready? Come on up. Yeah, let's do it. Are you currently on probation now? Okay, you need to realize that by pleading guilty, this can affect whatever probation you're on now. So the other thing is that the more cases you pick up while you're on probation, the higher likelihood you have of them revoking that probation and resulting in further confinement. Are you on felony probation or?
Your Honor, may I clarify?
Sure.
I don't think she understands. She's actually on parole. She did some time in Louisiana and she's currently out on parole. Is that correct? Not probation. She's already spoken to her parole officer. and
Okay, so they know about this.
They gave her permission to come down here. so
Great.
She could take care of this. And then she has her parole in Louisiana been moved to Virginia where she's currently living.
Okay.
So she's trying to
Great.
take care of everything.
Understand that if you violate that parole, they will issue what's called a blue warrant. A blue warrant is a parole warrant that they give. And if that happens, you'll go to jail and you'll be stuck in jail. You cannot bond out until you have a parole hearing. So it would be very, very good while you're on parole. Don't pick up any new cases. Don't violate the law. All right. So with
I never
us,
heard of blue warrant.
you are charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. They've offered you 3 days in jail with credit for the 2 days that you've done. You're now making a lifetime decision. Once you plead guilty to something, you're stuck with this forever. You can never come back and change this, undo this, challenge this. This is done forever and it will go on your record. What you also need to understand is this is an enhanceable offense. From now on, at least in Texas, you will be facing a minimum of 30 days in jail. Not only that, a third theft is a felony offense because they can use it to enhance your punishment. You understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this, you're stuck with this forever. You still want to do this. How do you plead to the offense? I will find you guilty. I will follow the agreement. I will roll your court costs so you won't owe anything, and good luck to you. Thanks. All right. Please see the clerk.
Thank you.
Thanks. Hey. Roseanne Zaragoza. Ms. Zaragoza, you're charged with 2 cases. You're charged with interference with the duties of a public servant. You're also charged with assault, bodily injury. Your cases are extremely old due to your flight. You've taken off 1 time. And I'm telling you now, you ever take off again, I'm going to make your bond extremely high. Do you understand? Do you have a lawyer today, ma'am? Do you have a lawyer today?
No, I don't.
I'm showing that probable causes have been found. So we figure out today what happens with your case. So I'm not ready for her to sign a reset, but let's reach out to the MAC. Please take a seat for me in the jury box, ma'am. Is it 3, 2, 3, 1?
3, 2.
All right. Good morning, Ms. Russell. Ma'am, you're charged with theft. You're facing up to 6 months in jail and/or a $2,000 fine. You've worked out an agreement where they're offering you 3 days in jail, credit for 2. Is this what you want to do?
Yes, sir.
So no deferred. She just wants to take the straight conviction. You realize that this is going to be a theft that goes on your record. It's going to be extremely difficult for you to get a job in the future.
Yes.
You still want to do this. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this,
yes,
you are stuck with this forever. You can never change it. Not only that, from now on, you will be facing a minimum of 30 days in jail if you ever pick up another case. How do you plead to the offense, man? I will find you guilty. I will follow the agreement, sentence you to it, and good luck to you, man. Yes, ma'am.
She's doing it.
You don't need a translator? Okay. All right.
It should be inside of the kiosk.
And it was the last. What was your last name again? Maiden. That's right. All right. Good morning, Miss Maiden. Ma'am, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement with offering you? I don't know.
Tops up this.
A lot of stuff going on. So. They've offered you 3 days with the credit that you have, so it'll be sufficient as far as the credit, as far as your time here. However, 4 days credit? Okay, so it's 3 days in jail with credit for the 4 days that you've done. However, you will not be getting out today because you still have a felony case that you need to worry about. You will hit felony court tomorrow. But what more importantly you must understand, ma'am, is that this now comes with an affirmative finding of family violence. What that means is that if you ever pick up another assault, even so much as grab someone's arm that hurts, you will be facing a 3rd-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. You can never own a gun or ammunition as a result of this plea bargain agreement today as well. You having a gun in your possession is a Class A misdemeanor in and of itself. You understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement today, you can never change this, undo this, challenge this. You're stuck with this conviction forever. You still want to do this? How do you plead to the offense, man? I will find you guilty. I will sentence you to the agreement. I'll roll your court costs so you won't owe anything, ma'am. Good luck to you. Thanks, guys.
I need the right now.
Oh,
Okay, hey, of course.
On Mr. John Newman's case, it's on your docket this morning, Judge.
Okay.
This is the young man who was in CPS custody and picked up cases in one home, has been moved to a different one, and is doing better there. I talked with the staff this morning. The state and I reached an agreement that he's going to do a thinking for change course in PTI conditions. The home tells me he doesn't really have that time within his schedule, but summer comes that he works. So the plan is to have him get that course entirely in the month of June.
Okay.
3 days a week to be thinking for change, but he's got their concessions now.
Is it the long, I guess, I assume you went the long thinking for change then? Okay.
It's the 12-week course, but it's in 4 weeks, 3 days a week as opposed to 1 day. It's just, I know the home has him doing different tasks.
The only thing is I would like to somehow verify that he's actually doing it, going through the rigmarole so we know that he's not wasting everybody's time. So how are we going to be able to check up?
Well, the staff there has been in good contact with me.
Okay.
And they tell me he's doing much better, not having any issues with any of the other kids.
Great.
Or any of the staff members there, participating in all the sessions. They got him going. So things have been trending much better since he's been placed in this new placement.
When do you want to set it to?
So, for your wisdom, but my thought would be, the Clinton suggested July, but if you want to do some session check, make sure he's enrolled.
I mean, I don't want to just set it all the way till a day that he's going to be done. I'd like, perhaps let's set it halfway.
Yes. Okay.
Check in, let me know that he's doing well. You're an officer of the court. I trust you wholeheartedly. So your word is as good as, so just let me know that he's doing well. And then we'll give you another reset for the end of July and hopefully he can complete it and get it done.
Thank you.
Yeah, for sure.
Hiya, Texas, Vernon.
You mean back there? You want to talk to me? Oh, okay. Salina Silva, come up. You speak English. Transferieron tu caso a el ERD, se llama, un diferente corte. Okay. Hey, Victoria, what's the address for ERD? I know, but I need to give him I want to give him the address so he doesn't go to the wrong place.
I think it's 1115 Congress.
That's it?
Yes, Judge.
Okay. Is it 5th floor, 4th? Do you know? Ramona, what floor? Do you know?
I believe 4th floor. But there's a sign right out in front. 4th floor, Judge.
Wait, they started putting in the elevators because people kept getting lost.
Okay. Does he have court today?
423.
Ok. Te voy a dar este papel. Dice que tú tienes corte el 23 de abril. Oh, no. What is it? We're in April, right?
Yes.
Ok. Abril 23 a las 11 de la mañana. Este es el dirección a donde tienes que ir. No tienes corte aquí más. Y si tienes preguntas, llámate a tu abogado y él te puede decir más. Oh, tienes que ir ahora a las 11, pero anda ahora a esa dirección. Piso 4, en el Congreso.
Yeah, what
Man,
he
you are
said.
charged with theft. You're facing up to 6 months of jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You're pleading guilty to this case. It will go on your record. It's going to be there for the rest of your life. You can never take it off. You understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Like I said, this is done deal forever today. You can never change this. You still want to do this, man. How do you plead to the offense? Guilty or not guilty? I will find you guilty. I will send you to the agreement. Understand, Ms. Williams, that from now on, you will be facing a minimum of 30 days in jail if you ever pick up another theft case. What's more is that a third theft case, you're facing a felony charge. Instead of days, it's years. you understand? Okay, good luck to you, man. Please see the clerk. How awesome is that? Number one, she's at the
Jury is present and all accounted for, Your Honor.
All right, everybody, please be seated. All right, good morning, ladies and gentlemen of the jury. Welcome to Court 5. This is a misdemeanor court. My name is David Fleischer. I am the judge here. And I want to really give you a heartfelt welcome. All of you guys live in a city that has roughly, what, 4 million people? Out of 4 million people, 3.5, 4.5, whatever it may be, imagine that a staggering only 5% show up for jury duty. It's absolutely, it's really mind-numbing to think that in a county as big as ours, where from one part to the other, it takes you 2.5 hours in a car to get from one part of Harris County to the other, only 5% of 4 million people show up. So you should really pat yourselves on the back. I'm proud of you. I'm happy to have you. And I so thank you very much, because realistically, our criminal justice system can't function without you. So what are you guys doing here? I know you don't want to be here. I don't want to be here either. I'd rather be in bed, but we all made it here. So I'm going to try to be as efficient as possible I know that your time is valuable, and I know you don't want to be here, so I don't want to keep you any longer than you actually have to be. So what are you doing here? This is court number 5. We have 16 county criminal courts in Harris County. The county criminal courts are those that handle misdemeanors. What's a misdemeanor? What's a felony? Well, what's the difference? I will tell you now that a felony and a misdemeanor, there's only but one difference: the amount of time that you're facing. Anything above a year is a felony offense. Anything where you can be punished by a year and under, it's a misdemeanor. So here, this is a misdemeanor court. Now, what's a misdemeanor? Well, there are 3 types of misdemeanors. They're classified by A, B, and C. A is the worst of the misdemeanors, so to speak, where you can be punished by up to a year in jail. And then there's a class B, which is the middle of the tier, which is punishable by up to 6 months in jail. And then you have a class C misdemeanor, which is a traffic ticket. Let's say Ms. Benavides over there, juror number 1, gets pulled over for speeding and she fails to have insurance. What's going to happen? Well, depending on where she is in the county, she's going to get a ticket, and then she may go to a justice of the peace if she's way back by Will Clayton by the airport. If she's near downtown, she may get a ticket to go to the 1400 Lubbock that everybody knows about, where that's so famous for traffic tickets. So because our county is so big, they have municipal courts and they also have justice of the peaces. But over there, they only handle class C misdemeanors, which are traffic tickets, and they are only punishable by up to a fine of $500. Here in county criminal courts, we handle class B and class A misdemeanors. So that's what we're doing here. So what are we doing today? We are here for a criminal case. I think that here everybody agrees with the law. I don't think that we have anybody that disagrees with the law. It's just did this person violate this particular law? And that's why we have you. The only thing I ask of you is to do one solemn thing. Use common sense. We are going to have 6 people here. You will listen to the evidence, and the only thing that we ask you to do is use your gut and your common sense and make a decision on whether this person is innocent or guilty of the law. We're not asking you to split the atom. We're not asking you to do brain surgery. No, just listen to what you hear. You know in your gut, you will know if the person who is testifying knows what they're talking about or if they're from outer space. You know, you've seen it, you've dealt with it, and all we ask you to do is put aside whatever feelings you may have, whatever preconceived notions you have, put it aside and just listen. You know in your heart, in your gut, whether the person testifying knows what they're talking about or not. Now, we have 2 sets of people here today who are going to do what's called voir dire. This is the process of jury selection where they're going to propound you with a bunch of questions to see, are you a proper person for this jury? Now, not everyone may be, and I get that. You may have had something in your life that has affected you in such a way that you can't be here, you can't be a fair and impartial juror. And if that's the case, so be it. All we're asking you to do is use common sense. Now, we are in trial. We will do jury selection today, and we will start tomorrow with the actual questioning of witnesses. Is there anyone who cannot be here tomorrow for any reason? Please raise your right hand. If you can raise your card so we can see what your juror number is. Juror number 7, tell me, you cannot be here tomorrow? What's going on?
I have a work trip to Dallas.
Okay. Is there anyone else that cannot be here tomorrow for any reason whatsoever? Does everybody here speak and understand English? Is there anyone here that doesn't understand English, even not so well, that you can't listen and make a decision?
I didn't understand English so well.
What is your juror number?
33, 28. Oh, easier. 28, sir. 28.
Okay. Do you speak and understand English enough to understand what's going on?
I speak English, but I did not understand the law.
If it's explained to you, do you think you'd be able to interpret the law and make a decision? And what juror number are you?
28.
28. Okay. At this point, I'm going to have the lawyers introduce themselves to you to see if you guys recognize anyone. Please state.
Morning, all. Mason Petron on behalf of the state. My name is Kevin Jones on behalf of the state.
Does anybody recognize them for any reason? Okay. Defense?
Morning, my name is Randy Yates. This is my co-counsel, Greg Stewart. Good morning. Mr. Gary Coleman.
Does anybody recognize anyone? No? Okay, guys, please be seated. All right. So what's going to happen now is they're going to hit you with a bunch of questions to see whether you are a proper juror in this case. Please answer honestly. No one's going to get in trouble here. The quicker this goes, the quicker you guys get out of here. And I guess without further ado, please.
Briefly, emergency approach.
Yes.
Clarify this before, but election is the punishment of the judge. So when it's brought up, in the event that it's brought up by a juror, I was going to answer it's going to be to you.
Hi, Miss Glow.
Okay. Got it. Okay.
All right. Let me try and figure out this system, see if we can do it. Okay, great. So my name is Kamal Petrov. I work on behalf of the President Petitioner Testimony Texas. I was born and raised here. I went to the University of Houston College and I'm also out of South Mexico. So kind of born and raised around here. I live mostly in Manville when I came back here. But that's a little background about myself. So the reason why we're here is because we're here on the state of Texas versus Jerry Quinn and trying to try to file intoxicated. Okay. And we're here on a jury trial because it's the defendant's rights. He has a right to a jury trial. So as he sits here right now, he's innocent. It's my job to prove that he's guilty beyond a reasonable doubt to y'all. That's my job. He has a right to a trial, which is he has two great attorneys right here. I have the entire burden of proof, so they don't have to do anything. They can just sit there and play crossword puzzles. If they can't believe I can prove this case, they don't have to say a single thing. It's all on me, and I bear that burden. He also has the right to remain silent. He does not need to testify, and if he chooses not to testify, you can't really hold it against him. You just simply cannot. I know sometimes people ask their kids, what did you do? And if they say, well, I have the right to remain silent, that's some evidence of guilt as a parent, but you can't hold that against them because it's his constitutional right to that. He has a right to discovery, which literally just means evidence, all the evidence that I have in my possession. He has a right to discover, to see, and he has a right to I have to share it with the defense. And the defense has the same subpoena power as the state. So any witness I brought here, I'm bringing by subpoena, they're court ordered to be brought here. They're court ordered to be here by a subpoena, and the defense has the same subpoena ability, court order a witness to come here as well. And he has a right to cross-examine my witnesses. He doesn't need to, they don't have to, but they have the right to in the event that they wish to ask any questions of my witnesses. Okay? Now, I intend for this to be more of a discussion. I know the first couple slides are more educational, but when we get to a discussion phase, I really appreciate for y'all to hold up your numbers and try to talk one at a time. And I only ask this because our court reporter here, as experienced as she is, there's just simply no way you can get two people's statements at the same time typed out, right? So the best way to go about it is raise a number, and when I call on you, you can answer. But let's try to avoid, people speaking one on top of the other, no matter how exciting the question is. Okay? So these are what I'm going to refer to as my elements. This is what I have to prove in my case. That in Harris County, Texas, the defendant, Gary Merrill Coleman, on or about August 26, 2023, unlawfully operated a motor vehicle in a public place while intoxicated. Okay, that's the charge. That's what he's being brought here for. So let's talk a little bit about intoxication. There are three different ways in the state of Texas that we can prove intoxication. Okay, one is the loss or not having a normal use of your mental faculties. And we're going to go over some examples. Or two, not having the normal use of your physical faculties. That's the second way we can prove it. Or, and the most common that we all see in shows is having a number above a 0.08, right? But there are situations where sometimes one piece of evidence doesn't exist, but the other two exist. And there's some times where, one is
healthy looking inventory means there's somebody streamlining some.
He's a professional.
There's no to object to this slide. It's an incomplete statement of the law. It has to be loss of, or not having the normal use of mental faculties, not having the normal use of physical faculties by introduction of alcohol. There's a bunch missing. It's just not the loss of those, or not having those normal faculties. It's because of alcohol.
Sure. So the law lays it out in the WI as not having the normal use of your mental faculties by the introduction of either a substance or alcohol. Not having the normal use of physical faculties by the introduction of drugs, substances, or alcohol, or having a BAC, which is a blood alcohol content of 0.08 or higher. Okay, that's the law. So if someone, for example, if someone loses their physical faculties, they're limping around, but they're injured, they're not really driving while intoxicated, right? They're actually just limping around because they probably broke their foot or lost, ability to use one of their legs. That's not by the introduction of anything. So part of intoxication is after proof that a substance was introduced in the body to have your loss of mental faculties or physical faculties or a blood alcohol content of 0.08 or higher. So this is where I wanted to start using this as a discussion. Let's talk about the introduction of alcohol. So what are some examples of a loss of a physical faculty by the introduction of alcohol? I know it's very wordy, but how does someone lose their physical faculties when they're intoxicated on alcohol? Someone raise their, sure, journal number one. Blurry vision, right? So I'm sure either we've witnessed or we ourselves have been intoxicated on alcohol. Blurry vision, double vision, these kind of things are loss of physical faculties because you start to lose your balance, for example, right? Who else? Journal number 9.
Slow response time.
Slow response, right? So your reaction time has now been slowed down by the introduction of alcohol, right? Let's say, you're walking to a staircase and you kind of don't register that there's a stair in front of you, right? And people fall downstairs, very prone. Who else? Journal number 15?
Decreased motor coordination.
Decreased motor coordination. So what's an example of that? I know.
Sure. So the example I can think of would be professional athlete isn't able to perform at their highest level if they're intoxicated or if they've lost their physical coordination.
So what's your favorite sport?
Hockey.
Hockey? I know nothing about hockey. What's your favorite team?
I'm a Boston fan.
Boston fan? Okay. And who, in your opinion, is the best player right now? Couldn't tell me, right?
Just like players.
Okay. But let's say you have a player that's usually very good, right? But he's intoxicated on ice. What's likely going to happen?
He's going to get hurt.
He's going to get hurt. How? Why?
There's a lot of people walking around with knives on their feet.
Oh, yeah. There's a lot of people walking around with knives on their feet. Don't get injuries like that, right? Definitely. Who else? Accelerate their education. Journal number 12, what was that?
Lack of concentration.
Lack of concentration, right? So you kind of lose your focus.
Yes.
Journal number 2? Sure. So stumbling, classic example, falling downstairs, or maybe walking to your house or your dorm. I'll give you an example, of course, easy example. My usual one is a college dorm. Someone's intoxicated going to their college dorm. Nowadays, your college dorm actually has a little keypad to put a number in, right? Maybe stumbling to your door. You probably won't be able to get in that door if you have, for example, double vision. So, what are some examples of loss of mental faculties? Journal number 1. Your depth perception is definitely impaired. You can't really see as far away when you're intoxicated. Who else? Sure, Journal 15.
Your reasoning is impaired.
Reasoning is impaired? Sure. 14.
Can't answer simple questions.
Cannot answer simple questions, right? You can't register what's being asked of you. Journal number 1.
Loss of memory.
Loss of memory. Okay, that's good. Anybody else? So
And loss of memory.
now we understand what loss of physical and loss of mental faculties, at least examples, are with the introduction of alcohol. We've all seen someone intoxicated. We all may have been intoxicated ourselves. So we have a very good understanding as adults what this is. And again, we're not asking you to leave your common sense at the door. You interpret it based on your personal experiences. So next slide, let's see. Okay, so blurry vision, loss of memory, all these mental and physical faculties. How would it affect your driving? Who here has seen a drunk driver on the road? 1, 2, 11, 16, 6, 5. I can ask probably every single one of you, right? And everyone has seen an intoxicated driver. So now I ask everyone, what are some examples when you see someone driving like, man, that person's drunk? Juror 6. Swerving in and out of your lane. Why would that happen?
it happens when you have somebody that's in class 16.
Yeah, right. Juror number 9.
Not paying attention to where the lanes are.
Not paying attention to where the lanes are, right? That's your loss of mental faculty, right? What else? Juror 29.
Driving too slow or too fast.
Too slow or too fast. I've seen both, so I definitely understand what you mean. Juror 5.
Driving the wrong way.
Driving the wrong way. That giveaway, right? Do not try and stop me, folks. They're not gonna register. All right, who else? Juror number 1.
Causing a crash.
Causing a crash.
Red light.
We've all seen that on the news. One way or another, someone's dead from a crash because someone's intoxicated. Someone crashed into a wall because they're intoxicated. Someone crashed into a house because they're intoxicated, right? Now, let me ask you all this. Who here has been affected by DWI in some way, shape, or form? And you can raise your hands high, and the only reason why is we need to sit down and fair and impartial jurors. So juror 16, do you want to share how you were affected by DWI?
I was hit by a drunk driver 12 years ago, broke both of my legs and my arm.
I'm really sorry about that. Will that affect your ability to be a fair and impartial juror in this trial?
Probably.
Probably. I'll need a yes or a no. And the only reason why I ask is because, let's say, I'm gonna give an example. So we got a yes from juror 16. I'll give an example for a maybe, right? I am currently engaged, a little bit about myself. I'm gonna get married in September, so I'm gonna go on a honeymoon in August. That's my plan, at least right now. And my fiance tells me, you can go wherever you want and do whatever you want, but I need you to promise me, you know, I need you to promise me that you're gonna be faithful. And I say, maybe, probably, right? How do you think September's gonna roll around? Maybe, back in the answer, right? So I'll need that kind of commitment from you all today, all right? So who else has been personally affected by driving while intoxicated? Juror number 1.
Yeah, I personally was involved and witnessed my sister get wrongfully arrested for driving while intoxicated. I personally experienced an officer wrongfully arresting me for intoxication.
I'm really sorry for your experience. But with that in mind, would that affect your ability to be a fair and impartial juror in this DWI?
I can't say it's
In this case in chief, right? Thank you for your honesty. Juror number 2. That is extremely serious.
Did she say that her son was hit by a drunk driver? Is that what she
Yes,
said?
sir.
Okay, it's hard to hear. Please, yeah, guys, try to keep it up because also Ramon is trying to record as well.
I know that's been very traumatic for you guys, as long as you're sorry that. Would that affect your ability, you can answer honestly, to be a fair and impartial juror in this trial? Yes, if interested in honesty. Anybody else? Juror 27.
Cousin and son were in
Killed by a drunk driver? And so, juror 27 stated that her family members were killed by a drunk driver. We're really sorry for that. Now I'm gonna ask you the same thing I've asked everybody else. Would that affect your ability to be a fair and impartial juror in this trial while intoxicated case? Yes. Juror 17.
I had a DWI when I was 30 years old.
You had a DWI when you were 30 years old. Yep. If you don't mind me asking, what was the resolution about it? I was guilty. All right, and would that affect your ability to be fair and impartial in your trial? Sure would. Yep. Yes, sir. I appreciate your honesty in that. Anybody else have anything else? Juror 4. I have a DUI as well. You have a DUI? Okay. And what was the resolution of that one? Convicted? And would that affect your ability to be a fair and impartial juror in this trial? No? Okay, thank you so much for your honesty. Juror 21.
I was definitely sure.
Thank you for that. How many, if you don't mind me asking, how many arrests have you made?
Long time.
I know, it's really hard to ask any honest. So, several. Okay. Would that at all affect your ability to be a fair and impartial juror in this trial?
That's not.
And have you ever investigated someone for DWI and let them go?
Yes.
And ultimately, there was some process that you did, right? Some investigation to reach to that conclusion, right? So that's what this trial is all about. Trials always are about, investigation, how we got here, why are we here, right? So now I'm gonna pose two hypotheticals, two evidentiary hypotheticals. I'm gonna ask for everybody to answer, and I'm gonna just call you out one by one. And it's a bit of a convoluted question, so if you need to look at the screen, you can always reference it back, okay? So we've talked about how we can prove intoxication by three ways, right? Loss of mental faculties, loss of physical faculties by the introduction of drugs or alcohol, or a blood alcohol content of 0.08 or higher. I only need one of those to satisfy and to prove beyond a reasonable doubt that an individual is intoxicated. So suppose I prove to you, beyond a reasonable doubt, which is my standard, that a person no longer had the normal use of their mental or physical faculties, the ones we talked about just before, and you believe it. You believe they lost their mental and physical faculties, but I don't really give you a number. I don't give you a blood alcohol content. Would you convict? So juror number one.
Yes.
Yes. Juror two? Yes. Juror three? No. Thank you. Juror four?
No.
No. Thank you. Juror five?
Yes.
Thank you. Juror six?
No.
No. Thank you. Juror seven?
No.
Thank you. Juror eight?
Yes.
Thank you. Juror nine?
Yes.
Thank you. Juror 10?
Yes.
Now juror 11?
Yes.
Thank you. Juror 12?
We need to know more specifics.
Sure. Yeah, I mean, it's a very generalized question, but my question is, if you believe that this person has lost their physical or mental faculties, but I don't give you a number.
Due to the alcohol. You don't drink.
Sure, that's fine. Yes, so in this hypothetical, we're talking about the introduction of alcohol. So I prove to you that he's lost some mental and physical faculties.
Is there any reason why this individual
I'm not sure if we can indulge in that much detail in this stage of the trial, but if you truly believe that someone's lost their mental and physical faculties by the introduction of alcohol, but I don't give you a number, would you be able to convict? Sure. I appreciate your honesty. Juror 13?
Yes.
Yes, thank you. Juror 14? Yes, thank you. Juror 15? Thank you. 16?
Yes.
Thank you. 17? No. Thank you. 18? Yes. Thank you. Juror 19?
Yes.
Thank you. Juror 20?
Yes.
Thank you. Juror 21? Thank you. 22?
Just for clarification, you said this wouldn't include the reason without the introduction of alcohol.
Yes. Yes, thank you. Juror 23? Thank you. 24? Thank you. 25?
I feel like it's not the question. But if you did say and prove that it was due to substance abuse or use in that moment, if that was the case.
Yeah, and you believe it. That's part of the question, right? And you believe it. But I don't give you a number. Would you be able to convince?
Your Honor, may I object? I just want to clarify that the law is that it has to be proven with proof that excludes all reasonable doubt, not just if you believe it. So I just,
Yeah, sure. That's why I'm
want to make sure they're
doubt.
holding it to the legal standard.
I mean, remember, guys, sometimes they may have a number, sometimes they don't. It's common sense. What if you see falling down, they've urinated themselves, they can't hold a straight face, you know? Do you need a number? Common sense. Listen, and then you make a judgment.
Thank you. 6. We're back to place. Oh, no. Okay, I didn't answer you though.
I answered.
Oh, that's it?
I said, if all of those things.
Yes. Okay, thank you. 26? Yes. 27?
Yes.
28?
Yes.
29?
Yes.
30?
Yes.
Thank you. Now I'm going to flip the facts. So suppose I prove to you beyond a reasonable doubt, which is my standard, that a person has a BAC, blood alcohol contents, of a 0.08 or higher, and you believe it. But I did not prove to you that they no longer have the normal use of their mental or physical faculties by the introduction of alcohol. would you convict? Now, this question is going more towards, the people with a higher tolerance. All right, so juror number 1. Yes, thank you. Juror 2? Thank you. Juror 3? Yes. Thank you. 4? Thank you. 5?
I have got to digest the course. I had to digest the course.
Sure, you can read
I'm
it.
looking at it.
Yes. Thank you. Juror 6?
Yes.
Juror 7?
Yes.
8? Yes. 9?
Yes.
10? Yes. Thank you. 11? That's yes?
Yes.
Thank you. 12? No. Thank you. 13? Yes. Thank you. 14? Thank you. 15? Yes. Thank you. 16?
Yes.
Thank you. 17? No. Thank you. 18? Yes. Thank you. 19? Thank you. 20?
Yes.
Now 21? Thank you. 22?
Yes.
Thank you. 23? Thank you. 24? Thank you. 25?
Is the law that 0.8 or higher is illegal regardless, or is it only illegal if you don't have your capacity?
So it's one or the other. So it's BAC of 0.08 higher, or loss of mental faculties, or loss of physical faculties. Was that? Yes. Thank you. 26?
Yes, sir.
Thank you. 27?
Yes.
28?
Yes.
29?
Yes.
30? Thank you. All right, so we got some multiple choice questions, nothing crazy, but here's a statement. DWI is a terrible epidemic in Harris County. The reason why I asked that is because we've all heard quite a vast experience. So 1 is strongly disagree, so 4 strongly agree. Juror number 1, what's your number? 2? 3? 4.
I didn't hear what juror number 2 said, I'm sorry.
Juror number 4? 3. Juror number 5? 4. 6?
4.
7? 8? 9? 2. 10? 4. 11? 12?
4.
13?
4.
14? 15?
3.
16?
3.
17? 3. 18? 3. 19? 20? 3. 21? 4. 22? 3. 23?
4.
24? 25?
3.
26? 3. 27?
4.
28? 4. 29?
3.
30?
3.
All right. All right, this is another statement. It's a very good use of the county's resources to find, arrest, and prosecute intoxicated drivers. Now, instead of calling y'all out one by one, I'm just gonna say, who's here's a number 1? So who here's a 1? Who here's a 2? Who here's a 3? All right, just keep your numbers up. So it's juror 3, 4, 7, 9, 10, 13, 14, 15, 16, 18, 19, 20, 24, 25, 29, 30. Who here's a 4? All right, 1, 2, 5, 8, 11, 17, 21, 22, 23, 26, 28. Okay, so the law makes it to where you can choose to give breath and you can choose to give blood, but you're not required to give blood or required to blow a breath. If I ask you, would you submit to a blood test and you say no, that's about the end of that conversation. All right, so a suspected intoxicated driver should be required to submit to a breath or blood test. I'll go juror number 1. Should be required. Two. Juror number 2. Juror number 3. Juror number 4. Juror 5. 4. 6,
I'm between 2 and 3.
between 2 and 3, okay. 7,
3.
8, 9, 2, 10, 3. Thank you. 11, 4, 12, 4, 13,
3.
14,
I can't between 2.
between 2 and 3. Thank you. 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30.
Between 2 and 3.
Thank you. Time? Still good?
Exactly 5.
All right. So we're gonna talk about beyond a reasonable doubt. I've kind of thrown that some around. I'll let you know right now, the legislator has not given us a clear definition. It's up to y'all to determine what beyond a reasonable doubt is. That's why we have jury trials. It's what you feel beyond a reasonable doubt is. Okay. So I'm gonna play a little, this did not work as I intended. Well, anyways, so it's not beyond all doubt. We have that from case law. It's not beyond all doubt. It's not beyond a shadow of a doubt, like Law and Order and all those shows say. And it's also not beyond some numbers. I can't give you, 51 to 49% or 70 to 30. I can't give you a number. I can't even give you any guidance on that. It's what you feel beyond a reasonable doubt is. So I made a 3-part test, and it's kind of something I've adopted. I think it's clarified some confusion about beyond a reasonable doubt to a jury. One is, do you have a doubt on the case? Would you mind? Is that doubt reasonable? And does it go to anything that I have to prove, any of my own? For example, if I prove my case, I have an Harris County, they were intoxicated, and they say, hey, it happened at nighttime, but they're saying it happened in daytime. That part doesn't really go to an element of my case. So part of what you have to determine is there a doubt? Is it reasonable in your mind? And does it go to something I have to prove? That's the easiest way I can verify it. We'll skip that part because I only have 5 minutes left. I have a couple wrapping up questions. These are the 3 I usually ask. Is anybody here unable to sit in judgment of another for any moral or religious reasons in trial? And you can be honest. This is your point to be honest. Anybody? Do you have any questions for me? Sure, during fire.
On no refusal, you can't refuse blood test anything.
Well, you can refuse to give a test, and the law or the procedures criminal require me or the officer that's investigating to write up a blood warrant on what they believe is a probable cause to seek your blood to then test it for a blood alcohol content. So there are ways, but you can refuse. You can refuse blood, you can refuse breath. That's your right. And at that point, if the officer believes a probable cause that you're intoxicated, they can get a blood warrant signed by a judge. That's the procedure.
So when they advertise that on television, that's not true.
What's that?
No refusal weekend, because sometimes on the holidays, they say no refusal.
Yeah, no, not sure. You need to get a warrant. If you're gonna refuse, there needs to be some probable cause to write up a warrant and draw your blood. They can't just go willy-nilly, especially after you say you don't want them to do it. Journal 19.
I don't drive. I don't have to drive this license. I can't hear her. I don't drive.
You don't drive. Okay, I appreciate that. I appreciate the honesty in that.
Okay.
Anybody else? I saw somebody else right there. Okay, 17.
Don't they take away your license if you don't submit to breath or blood?
It's
automatically.
No, it's subject to license suspension, but there is what is called an ALR hearing, where if you're present and you have a hearing with an attorney, there are some provisions where you can keep your license. Definitely not probational. So, yeah, there are ways around that. Does anybody else have any other questions? Is there anything else I should know about you that would influence your ability to be a fair juror? Just anything at all. If you don't want to share in front of everybody, that's fine. You can share one-on-one in the bench later. I just need to know if there's anything that you haven't shared that you think we should know. that would affect your ability to be a fair and impartial juror. All right. Thanks, y'all. I really appreciate it.
All right, thank you so much. Right on time.
Thank you, Judge.
Okay, Mr. Yates, the floor is yours.
Thank you, Judge. Morning. So then, this new packet has all y'all's information on it. Where you're from, where your address, age, family, children, all that good stuff, right? So in fairness, I think I should kind of keep in mind, we're here to learn about each other, right? So May the 8th, Saturday. This Saturday is his birthday. I have 3 kids, they're all boys. They are 5, 6, and 9 years old. And I went to law school in Houston, went to Tech. I was born and raised in the Spring area, so I went to Fine High School. So I went to Fine High School after 99. So, me, this is where we're supposed to learn about each other, right? Well, I need to know your thoughts, so we're here to talk and kind of get to know each other a little bit. First thing I want to say is prosecutor, Mr. Dalwell mentioned it, that we're not here to define simple law. We agree with the DWI laws. I drive on these same streets with my kids, and we agree with the laws. We just don't think the evidence in this case is where our disagreement is, okay? So who walked in and whenever the state put up and said this was a DWI case, anybody just kind of sulk and say, oh, this is not the case for me? Anybody kind of feel that way? Yeah. If you could raise up your placard. And the state kind of touched on this a little bit. Number 2, you mentioned it, thank you very much. Anybody else have that placard that was up? Number 16, you mentioned it. Number 17, you mentioned it. 27, you mentioned it. Great. So I'm not trying to duplicate here, but just want to kind of touch base. There's no additional people there. Just kind of saw that. I was like, I don't think this is the case that I should be. Obviously, I don't expect your answer to be good, but I want to know how you feel about DWIs. How you feel about the law of DWIs. If you have a personal standard versus like a legal standard. Does anybody think that we should have a 0 tolerance DWI policy where any amount of alcohol is considered driving while intoxicated? Did you see those text stop signs, right? What do those text stop signs say? Anybody? Driving on the road, they say drink, drive, you pull over. They say pull over?
Drive over, forget all that.
Drink, drive, we're getting close.
One drink, you should not drive.
1 drink, you should not drive.
Period.
Period,
You have a
okay.
choice.
And that's in your number 12. Okay, so 1 drink is the limit. You know if that's the least?
No, you decide to drink, and then you put your piece in somebody else.
Okay.
We don't know.
Anybody else feel that way? 1 drink is the maximum that
We
you should
all
be
have
able
to
to.
be responsible
Okay,
for other people's lives.
is that 1 standard drink? Do we kind of know what the standard drink
It
is?
just, any
Any
alcohol drink.
Any alcoholic, okay, so we'll have that. Any alcoholic drink, all right, number 12,
About
please,
mouthwash.
1 drink, anybody else agree with that? Number 11, you raise your hand. Number 23, 1 drink, anybody else agree? 1 drink should be the limit? Drink.
1 drink and taste.
1 drink is, you drink 1, that's it, you put your piece away. With this fine, at that point, 0 tolerance.
0 tolerance.
0 tolerance is what I said.
Okay, $0, that's your personal standard.
Yes.
Okay,
Because I choose not to drink. It's my choice.
okay, and you mentioned that there was no alcohol, that you don't drink alcohol. Do you think that you're gonna hold, Mr. Coleman to your personal standard? If he has 1 drink, that you're gonna find him guilty?
Well, if he's coherent, and some people, like you say, when they drink a lot of custom, and they become immune, and there's a proof that they did not want, have have any influence, the alcohol didn't have any influence, and you could prove to me.
Thank you very much, I appreciate you. So is drink, drive, go to jail, is that the standard that we're held to in our legal system for driving while intoxicated? No? What does almost every bar in the city have out in front of the location? The parking lot, which side of the thinking, why are the parking lots there? Car. Appreciate it, right? The bars have parking lots, because cars are there, because in Texas it's legal to consume alcohol, not lose your mental or physical laws of the norm, not having laws of normal and physical faculties, right? Those standards that the prosecutor laid out. You can have a drink and still be legal to drive in Texas, right? Or multiple drinks if you still abide by those rules of law, right? And does anybody know this?
I think Texas is wrong due to the fact the rodeo, they get drunk out there all the time. And yet they drive and don't get them tickets like they get regular people. I will say that.
The Cowboys are different.
But it's a money maker.
It's a money, okay.
Also, it's money.
I got it. So the city, they make a lot of money and they look the other way.
Yeah, see, I'm a retired bus operator. I used to take them to the rodeo. I'm from the rodeo. And it's just ridiculous. But the rodeo has been going on in Houston for years and they still do the same thing.
Okay, I appreciate it. Thank you very much. Does anybody know when the .08, the blood alcohol content of the .08, when is that relevant to a DWI case? Yes, ma'am, number one. We have at the time of driving, that is correct. So does it matter what the BAC was at the time of a breath or a blood test? Is that relevant? Sorry, you were about to say something. No, okay, just like, all right. See you, thank you. Yes, ma'am.
It's not proof of that time of driving, but it can become relevant.
Okay.
We're making a decision of what the case is.
Okay, but the actual standard is .08 or higher at the time of driving. Yes, sir.
I was just going to say it would depend on when the test was.
When the test was administered. Okay. All right, so just wanted to make that clear that it's within the law that it's .08 at the time of driving, make sure they're all on the same page. So number 12, you said that you didn't drink alcohol. I appreciate you sharing that. Does anybody else not drink alcohol? Number 2, and if you don't, if you can hold those up or run, move on. If you don't have to hold those up, move on, you can stop. Do you mind sharing why? If you have a reason, if not, a personal choice. Okay. Number 6.
Oh, I don't drink.
You don't drink? And is there any specific reason why?
No reason. I just choose not to.
Okay, choose not to. Appreciate it. Number 11, you don't drink alcohol. Okay. Is there a reason why? Your husband does not. Number 12, you have a reason why, and if you don't, that's fine. If you do, you'd like to share that, appreciate it.
It's just a personal choice.
Personal choice, okay. Number 16, you don't drink alcohol, so is there any reason why? It's just personal choice. Okay, number 18, you know, personal choice. Number 23, personal choice. That's personal choice. I'm kind of in the boat with you. Anybody else? So I drink probably 10 drinks a year. Okay, if I have one a month, that's pretty much it for me. So I'm not exactly where some of y'all are. I'm close. I don't drink regularly.
I do drink every now and then, but I don't do it while I'm drunk.
Okay, thank you very much. Appreciate you sharing. Yeah, so alcohol is not a big part of my life either. If I was in this thing, I kind of on the current side of the movie. You know, I'm talking about, you know, I don't drink on a regular basis. We already talked about that. So the state's burden of proof is beyond reasonable doubt. We talked about this quite a bit. If we break that down, we can kind of figure out what all of these words mean a little bit, right? So the first one is beyond. And my school teacher might be able to help us out. Anybody else? If I said, what is another word for beyond, what would you say? Like a synonym of beyond. What else means beyond? Number 15.
Surpassing.
Surpassing? What did you say?
Surpassing.
Surpassing. Okay, I like that. Surpassing. That's a good one. Over. Okay. Over. Beyond. How about the second word, A? Just letter A. A, reasonable doubt. So what is A to the scenario? Number one. One, that's right. So just one, right? So we got to get past one. Now, reasonable is where it's kind of squishy, right? That's where the law doesn't define it. Reasonable is left up to you as the truth. So you can kind of figure out what's reasonable to each and every one of them. And doubt. Does anybody have anything that they want to say? For doubt, what is another word for doubt? Unsure, right? Okay, unsure is a good one. Any other? Questions. Questions, we can agree on that. Thank you. So if you translate it into, I think, non-legal stuff, more of a common language, I think beyond the reasonable doubt would be past one squishy question, right? That's question 3, right? And what does that mean, right? That's up to each and every one of us. And what the law does say, though, that you have to be 100% past a reasonable doubt. Can everybody hold the state to that standard? Number 1.
As to each and every element that are.
Okay, yes, the elements of the crime. So we're all in agreement that if you have one doubt on any of the elements of the crime, then that is enough reasonable doubt not to convict, right? Okay. So one of the big keys to not getting on this jury, and Judge kind of talked about it, and that nobody really wants to be here. I love being here. It's my job. It's my life here. But if you're trying to get off the jury, you got to talk, right? The more you talk, the more we get to know you, the more reasons either the state or me have a reason to strike you from this jury, right? So if you want to get on this jury, remain silent. That's the way to do it. But if you want to go eat lunch on your own, speak up. We can start giving you your opinions. I got to get to know you. I got to hear what you think. Why do you think that? All right. So, yes, ma'am.
I just remember a friend of mine. She talked me into doing. She took me into just trying budget. I did. That was enough for me. I was busy. I could not walk straight. That's why I say take that one.
Thank you very much. So there's kind of different levels of proof, right? So let's say that, all right, so the first thing, the very highest level is going to be the actual proof, right? What do we have below proof? If the state tries to admit something, they're admitting what kind of document, video, what would you call it? Evidence is number 11, evidence, right? And so is evidence necessarily proof? You think evidence is proof? Okay, so I'm gonna get back to that then. I'm gonna circle back to the okay? Below evidence, what do we have? We have assumptions, right? I think they did this, I don't know, right? I'm not sure. So if I told you that the earth was flat, do we have any flatlanders in here? The earth is flat? No? Okay, so I walk outside and I say, if I put this pin down, I think it's going to stay where it is because the earth is flat. Is that an assumption? Or is that evidence or is that proof? It's an assumption, right? We don't know. I haven't done it, right? But if I actually go and put it, hypothetically, we're outside, not in the building, I'll put the contractor's level of it. When I take that pin and I set it on the ground, and I say, right there, the spot, there's evidence that the earth is flat. Do you believe that evidence? No. And so, does that mean that it's proof that the earth is flat? Because there's some evidence there that the earth is flat, right? Because the pin didn't roll away. No, but it doesn't go all the way to proof, right? It's merely, here's evidence that the earth is flat. Now, I know, well, you said none of you believe that the earth is flat, but we can assume that the pin will roll away, and then we can see that the pin doesn't roll. We can assume the pin won't roll away. We can see the pin doesn't roll away, but I don't think that proves that the earth is flat, right? You see where I'm going up to different levels. We gotta hold them to proof, not to assumptions, and not to just evidence. All right, so this is the law that I kind of want to go over and make sure that you understand the law and how they work.
How much time does he
you're
have
willing
left?
to agree to follow. So let's hypothetically, let's say that a car gets pulled over and the police officer in this investigation opens up the trunk of the car and it's full of guns and drugs. Okay, nasty guns, nasty drugs, whatever you want to imagine the worst kind, right? So the police officer arrests him, he comes to court, they go to trial, and during trial, the police officer is asked, why did you pull it over? The police officer says, well, this car is green, and I don't like green cars, and so I wanted to stop. And there's no other reason to stop, merely that the car was green. Okay? And so under the Texas Code of Criminal Procedure, 3823, you can't use evidence that's illegally obtained. Okay? So if the car is green is the reason for the stop, and that's the reason why we got pulled over, and that drugs and the guns is admitted, can you overlook the drugs and guns that were in the car and say that he was not guilty of possession of drugs and possession of illegal firearm? Could you overlook those charges and vote not guilty on that if you thought that the evidence was collected? All right, so let that marinate for a second. I'm going to go through and ask everybody if they could say, I want you to say I would vote not guilty, but yes, I could vote not guilty in that scenario. The evidence is clear that he had guns and drugs, but the reason that it was collected was illegal. Did you vote not guilty? Yes. No? Like and so that's something that you feel, right? Something in your heart of hearts. You would not change your mind on that. You would say, I could not overlook that evidence. Okay, so you would vote not guilty. I'm sorry, you would vote guilty on that. So, okay. Number 3? I would vote guilty. You would vote guilty. Clearly violated. So it doesn't really matter how I got it. Okay. And that's in your heart. You wouldn't change your mind on that? I don't think so. Okay. Paul's going to Vegas for his bachelor party. Is he good to go? Just be careful, yeah. Can I get a yes or no? I think so. I was the point that I can't have an I think so. Yeah.
Well, it's like you have to follow the law. The law clearly states that evidence, you can't look at the evidence because of the way that they came by it.
Correct. That's what we get. But you still want to see that evidence, and you still want to vote guilty.
If the evidence pointed to guilty, I would want to vote guilty.
Yes.
Yeah, I think yes.
Number 4, vote not guilty. Not guilty. Was I? Not guilty. Not guilty.
Not guilty.
Not guilty.
Because they don't have enough evidence to prove that the person is guilty, even though the car is green.
Okay. Does anybody have a green card? Number 7. You can vote not guilty. Number 8.
I'll say not guilty. Not guilty incentivizes bad behavior by law enforcement.
I'm sorry.
I think it incentivizes bad behavior by law enforcement. Straight to evidence, so keep it on that.
Yeah. To be clear, we're not planting.
Right. I think it leads to that door being.
Okay.
I'm sorry, sir. Repeat that last part.
It leads to the door being or worse behavior.
Did that? Okay. Number 9, not guilty. You vote not guilty. Okay. Not guilty. Not guilty. So we're all overlooking the guns and drugs. Number 11. Guilty. Number 11, you find guilt. That's what you feel, right? And nothing changed your mind about that. Thank you. Number 12.
What was the reason why people had all this in this car?
He's guilty.
Unless he's a police officer.
Okay, his activity is illegal. Okay, that's what you feel, you wouldn't change. Okay, thank you. You think?
I'm not guilty.
Not guilty, all right, thank you very much, I appreciate it. You don't know. Point flip. I can't hear that. Great thinker? Gray thinker. Okay, so it's not black, oh, gotcha. Okay. Possibly guilty. Okay. 15, not guilty. 16,
I would say guilty because a good defense attorney would get it thrown out.
guilty, okay? And you feel that in your heart of hearts, that's kind of, you want to change
Because
it?
if they didn't get the evidence thrown out because of the way that he was stopped, then they let it go to trial and it's guilty.
Okay, thank you very much.
Not guilty.
Not guilty. I'm sorry, what did you say? I kind of lost track. Number 18. Guilty. Okay, and that's something that you feel like you would change your mind on that, and in your heart, deep down, you would have to vote guilty on that. Thank you. Number 19. Guilty. Guilty. Guilty, and y'all aren't changing your mind. 19, in your heart of hearts, you feel, right? Thank you very much. 21. Not guilty. Thank you very much. 22. Not guilty. 23. Not guilty. 24. Not guilty. 25.
I don't like it, not guilty.
You don't like it, but not guilty. Follow the law, right? Look, it's guns and drugs. I don't think anybody's going to like this, right? I mean, some people, but we're probably not citizens, right? I understand it. It's not something that. I just need to know if you're capable of following the law and, right? If I lost track. Okay, number 26. I was trying to count. 27.
5 minutes, Mr. Yates.
Thank you, Judge. I'm sorry. Not guilty. 28. Guilty. Guilty. 29. Not guilty. 30.
Not guilty.
Not guilty. Okay, thank you very much. I know it ate up a lot of time on that, but that's okay. Number 21, I believe you said that you were a police officer, right? You're a former police officer? That's not what's written down, is it? Doesn't matter. When we get that little sheet, I didn't think I saw a police officer on it, is it? Long time ago, okay. Nobody else is a police officer or former police officer, are they? Number 5, former bus driver and former police officer. Military police. Military police. Thank you for your service. I appreciate that. Thank you very much. And so expanding beyond just yourselves, anybody have parents, siblings, anybody else who's a police officer, an attorney? Like your close family, your parents, your siblings, your spouse. Number 1. Cousins that are officers. Thank you. Cousins on corner, bro. That's a lot of law enforcement. You kept the straight line, huh?
I do have a few family members that serve in our military.
Thank you very much. We appreciate it. Thank you for sharing. Number 8, cousin's attorney. Your cousin's an attorney. Is it local here or no? Okay. We have an ADA, Harris County ADA. She works in this courthouse. Brothers, sorry. Your brother is an attorney. Okay. Criminal attorney, prosecutor. Number 14?
My stepdad.
Your stepdad.
My stepfather is a deputy.
You're local in Oklahoma. Okay. 16?
My brother-in-law is a narcotics officer here at HPD.
narcotics officer, anything? Number 21, we got, I'm sorry, go ahead. You elaborate.
My brother was retired ATO.
Okay, that's fine. You probably be involved in the drug and gun deals. Anybody else? For the people who did share, if they have law enforcement in their family or attorneys, would any of y'all give more weight to the officer's testimony simply because they are an officer? You know, so you would start that officer at the same credibility as everybody else who is going to walk in here in uniform? Okay, just make sure everyone start off on a legal playing field. All the witnesses. Is there anybody who's not supposed to start off on a legal playing field? Did anybody have an advantage or start off with an advantage in this case? No, Gary. Is he presumed innocent? Are you supposed to, did you have any preconceived notions about his guilt? Does anybody think that if he's already done something wrong because he's sitting there? Does anybody feel that way when you walk in? And just because he's here, he has to have done something wrong. No, he starts out at zero, right? He starts off with the advantage. He has to be proved guilty. He is innocent until proved guilty. Right? He has that presumption. All right, a few other things and I'll wrap it up. We have a couple of people who served on the criminal jury before, and I don't want to ask you about the case or anything like that. Number 5, did the judge assess punishment or did the jury assess the punishment? The judge assessed the punishment. Number 25, that as well. You know, if the judge assessed the punishment or the jury?
They actually had to release this after starting trial because this came forward and they postponed the trial to later.
Okay. Nobody else served on a criminal jury besides you? Agree?
Yes, there's excuse me, a murder trial.
A murder trial.
That time.
Okay, so you know the punishment, the hair's class, and you know the judge or the jury assessed punishment? The judge of the jury. Okay. Number 29, you served on a criminal jury? Yes. And did the judge or the jury assess punishment? This is before you had to do a verdict. Thank you. Number 30. Jury assessed punishment. Thank you. Okay, and then I didn't tell you that I was an attorney, but I think you can presume, right? But a lot of these had retired, not available, or not applicable, or it's just blank. So if it was that way, if you don't mind sharing what you used to do, what you couldn't do. Number 3, you didn't have anything listed on there. Are you retired? You're retired. Congratulations.
2 minutes, Mr. Yates.
I used to be in information technology.
Oil company, information technology, a lot of business experience. Number 5, thank you, shared with former police or military police, excuse me. Number 9.
Yeah, mechanical engineer.
Mechanical engineer. Okay, thank you very much. You may have made a mistake. That says self-employed.
Yeah, I just got it.
There you go. Congratulations. Number 10.
Engineer.
An engineer. And who do you work for?
Flight aware.
Flight aware?
Flight tracking.
Flight tracking. I use it all the time. I used to work for United Airlines before I became an attorney. I see we got a lot of United employees in here. Those guys over there. Number 10. How was you? Sorry, I didn't move my phone over. Number 11. You used to work at a liquor store too. Did you have any special training or anything from THC while working at a liquor store? Did they train you or anything, or was that just like bartenders and liquor stores? Okay, thank you very much. Number 11.
1 minute, Mr. Yates.
Thank you, Judge. Auto technician, thank you very much. Number 19. Thank you. She just, do you want her to say it or just? Did you say that again?
I'm
it's hard to be unemployed. I have a master's in social work, but I used to work with children.
Number 23. I'm sorry? Congratulations. It's an awesome job. Thank you very much. All right, so kind of how the state ended it. You're sitting there and you're thinking, man, he hasn't asked this question, or he should really know this about it. Does anybody think like, hey, this would be really important? I haven't spoken out about it, but I think they should know. Nothing. All right, sit down. Thank you very much for your time. I appreciate it.
Okay, Lori, you want to come up real quick? All right, so at the outset, let's address the two that cannot be here tomorrow. Juror number 7 and 28. Juror number 7 can't be here tomorrow because she's, I guess, a flight to Dallas. Juror number 28 didn't understand English very well. So I'm just going to go ahead and take them out for cause now. And then, okay, so state. Yeah. Okay, hold on. 4 and 6, that's all you have?
On the first one.
Okay, tell me why 4.
So 4 and 6 on my first one. So also meant towards physical, but I don't have a number. They said they would not come in, so they can if I do one, you know.
Both of those said that?
Both of those said it, yes.
Juror number 4 and juror number 6. Do you mind coming up real quick, please? Guys, do you mind making just a little bit of room? All right, coming up, guys. I won't bite, I promise. All right, so Pavel asked you a question earlier that if he didn't prove to you or didn't give you a number, you couldn't convict, right? But the law is not, sometimes you may have a number, sometimes you don't have a number. I don't know what's out there until we actually get the case and see what's going on. But let's say that they produce other evidence to your satisfaction, right? Yes. They've got, for example, like some kind of video, like I said, that the person's falling down and you've urinated on themselves. Do you still need a number, or is that sufficient?
Not in that case.
I'm sorry? You wouldn't need a number. Or you would need a number still. Because the question is, you know, are you going to be able to use enough of your, you know, I guess it would be common sense and background that you know when someone's intoxicated. Do you still need a number or no?
Not necessarily. No.
What do you think? Do you want to ask any questions to them? Okay. It's just the only thing that we're asking you to do is use common sense. Right. You know when someone looks intoxicated. You will get evidence. You're going to hear and just make a decision. Is there anything that you guys wanted to ask? Okay, guys, please. Yeah. Okay. Well, all the questions that you guys are asking were commitment questions. Just no one object. because I wouldn't have let it in.
If you ask if they believe it, and if it doesn't believe it, if you ask if they genuinely believe it. So, we've specified more examples.
I'll reserve my ruling for now. Let's go on to see what they say about 4 and 6 when they get their turn for cause, and then we'll see. Okay?
What did we agree for, Judge?
You'll agree to 4. 1, 2. Okay, so I'll grant for 4.
Motion. My question is just 17, and actually she has a lower. So if I prove also mental and physical and also on the index.
Should I just skip
So
this
that's
part?
the only one the other have on the second one?
Yeah. Yeah, in addition, there's also something different. But that was from 1989. Yes. That's the only one I'm just.
So you say 12 and 14?
12, 14, and 17 of the second one.
Juror 12, 14, and 17. Do you mind coming up real quick, please? Oh, no, juror 12. That's fine. You can just take a seat. Let me have 14 and 17, please. Hey, I'll agree with you on 12. I will agree with you on 12. Yes. I'm going to agree. I'm going to agree on 12. I think that's for you as well. Thank you so much for coming. I appreciate your time. Thank you so much for coming. So he posed the question to you earlier that if you didn't have a number, you wouldn't be able to convict. Like I asked you earlier, the only thing that we want is common sense. You know what a drunk person looks like. You've seen a drunk person. In fact, you may have been drunk as well at one point in your life. I know I have, right? If you see something and they've proved to you, like on video, you see something, right? That you know in your heart is intoxicated. Would you still need a number? Yes. Even though you know, but that's not the, no, it's not the law. Right, but sometimes they may not have. See, back in the old days, you didn't have any of this stuff. You didn't have field sobriety tests, you didn't have blood tests, you didn't have breath tests, you didn't have any of that stuff. The only thing they are aids to convict, right? But common sense dictates that if you see someone and they're falling down and they're just urinating, you know, right?
No, you're right.
Would you still need a number?
No.
You know? Right, that's why I'm saying common sense. I know I would like to win the lottery, but sometimes it's never going to happen. You know what I mean? Right? Sometimes you're just not going to get a number. You're not going to get what you wish in life. That's how it goes. But they can still make a case without it. They don't need all this fancy schmancy stuff, you know? No. They might be able to produce something else. And if they can produce something like a video or something else, a witness testifying, and you believe it, can you still convict? Right. That's what it's about. Open mind, you look, and you make your decision, right?
Your Honor, may I address the question?
Well, hold on. I'm going to ask him first, and then I'll get to you. Do you want to ask anything?
The only thing I was going to bring up was, I think the both ministers have answered the inverse question. That if you had a number that didn't have.
Correct.
That didn't have any sort of
Say it again. So repeat the question. So if they had above, so the question is if they had.
They had a number that no less than physical faculty to basically be able to convict. Okay, but that was the second question.
Okay, so pose the question, because I didn't hear that. Remember, there's three different ways that they can do it. Loss of the normal use of mental or physical, or through the introduction of alcohol with a 0.08 or above. So there's three different ways. If they do the 0.08, would you be able to convict? Tell me. So they use the third method where it's above a 0.08 and they prove it to you. So remember, not everybody's like you, right? Not everybody's like you.
I understand.
Okay, that's all right. Okay. What do you think, sir?
Oh, I just leave on me. So I said
would not be able to.
No, because that's fine. I have a high tolerance.
Okay, thanks, guys. You may be seated. I got it. Oh, granted. So that was 14, 17. Okay. Anyone else?
Just asking my notes here.
It's okay.
We get a ruling on?
Yeah, I granted 14 and 17.
How about 12?
Yes, and 12.
12 was
gone. Come on, man. You going any slower, you'll be going backwards. Where are we going? What's third love? No? Okay. Go, first row.
So,
hey, guys, ready? He's going to say.
Thanks, Sherry.
So 11 would say that she'd hold somebody.
I'm making an executive decision to fast forward through some of this. I'm going to post the entire thing on my Patreon. So if you want to come back and see what we missed.
Guys, you're in the home stretch, I promise. So here's what's happened now. So what we did are our 4 cause challenges. We wanted to see who is a good person, who is not a good person. It's okay. No one is right. No one, I mean, all is right. No one is wrong here. Like I said, not everybody is a perfect juror. For this case, you may be great on a breach of contract where a contractor suing a builder or some kind of breach and that's okay. What's happening now is when I'm giving each party another opportunity to strike another couple people that they don't want on this jury. After that, after they've made their strikes, I will get the state strikes. I will get the defensive strikes. After that, I will reconcile the list. The first 7 people will come and sit on this jury. Now, I want to thank you so much for coming. You really did a great service today. I know it's taken half of your day, and I'm sorry, more than half your day. And I'm really, truly just thankful that you made it, because like I said, we can't function as a society without you guys. I hope that this hasn't soured your experience, and that if you're called upon, you'll come back. The good news is that because you came and participated with us today, from what I hear, you will not get another call for another 3 years. Don't hold me to it, but that's what I hear, okay? Don't sue me. But again, I want to thank you. We're in the home stretch. I've given them 5 minutes to make their strikes. After that, I'll call the jurors, and then that's it. And then you'll go home. You can get up and stretch, but just don't leave.
But he's still got to get the interlock installed and the fee paid. So, but he does have all the contract and everything signed back to me.
Okay. So you're ready to submit it? We just need to set you off a couple weeks to get the interlock and the DA fee. That's it, right? Brian?
Yes, sir. Yes.
Okay. All right, come on up. So you still wanted to work this thing into a dismissal, right, Mr. Lewings? All right, come on up. I mean, you're literally in the home stretch. Because I'm telling you, you're going to pay it one way or the other. If you plead guilty, you're going to pay for it threefold as if you were to get this thing dismissed. I promise you. And you're in the home stretch. All you need to do now is get the interlock. But you're not.
Actually, Judge, I apologize. I don't mean to interrupt. It's a portable device because he doesn't have a car. He doesn't drive, so it's a portable device.
That, you pay the $300 DA fee, and then you're into the program. That's the only thing you got to do now.
There's another $100 fee on there. I saw it was like there's a $12.50, there's a $60 to initiate, and then another $100. So I think it's like $472.50.
I don't know. No. But there's also a district attorney's fee that you have to pay.
So an additional $300.
It may be included in what you're talking about, but I'm not sure. So let's do this. I'm going to give you 3 weeks to get this thing done. Okay? That should give you plenty of time. If you can get all that stuff done before the next setting, I will waive your appearance so you don't have to come here.
I'll come back. I don't mind coming back. I don't do any drugs. I'm trying to go see my mother, and I've been
have to do this regardless, though.
I understand
part of the agreement. So I'm helping you, right?
I'm talking about the call-in every morning.
Okay, we'll work something out with you. Okay. For now, I'm going to set you off 3 weeks. You got to get the portable device, and you got to pay the $300 DA fee between now and that time, and get the proof to your lawyer. He'll get that stuff to the DAs, then they'll file the supervision order, and then you're in the program.
Yes, sir.
You're in the home stretch. You've made it this far. All you need is just literally just a little bit more. And look, the benefit is that you'll get this thing dismissed.
It's a hard reality considering I was helping people who were in a car accident. I wasn't even.
That's beyond the point. No good deed goes unpunished, as they say, right?
That's crazy.
All right. So I'm going to give you 3 weeks. Get it done. Call Brian, so you guys remain in contact, so you can get on the same page. All right?
Yeah, I didn't know that he contacted
me. He thought you had court on Thursday, not today. That's why he's not here.
That's fine. What about the call-in, sir? You can test me now. I don't do any drugs. I'm on medication. I can't do any drugs.
I don't know that. I don't know you.
I'm saying you can drug test me now if you want. I'll take a mouth swab, whatever. Like I don't.
We'll work something out for now. But for now, I need to get you out so we can help everybody else. All right. Brian, give me a date that you want 3 weeks.
Let me check my calendar, Judge. Hold up. Does the 15th work, Judge?
I'm cool with it.
Okay.
Yeah.
Sorry, I apologize. I had it in my calendar. I was going to zoom in on Thursday morning. I don't know why.
It's okay. Make sure you have it this one. All right.
May 15th, Wednesday. Got it.
You got it. Okay.
Yes, sir.
You guys get together, please. Okay.
We will. Like I said, he's been going back and forth getting everything done. He just hasn't had the time yet.
Okay. All right, thanks, Brian.
Thank you, Judge. Sorry.
Bye.
That's partially my fault. I have bad reception.
Don't worry about it. All right, let me see. Okay, Luis, you're here. You ready? Come on.
I have this order.
Yeah.
Go around.
Rico Romero.
Buenas tardes, ¿qué tal? Soy Luis, el intérprete, mucho gusto. Párese aquí, por favor. Este cuadro aquí adelante, solamente mire después y le contesta nada más en español, por favor.
Are you Rico Romero?
Rico Romero, yes.
We're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford a lawyer will be appointed to represent you.
Officer observed two speeding trucks traveling in Harris County, Texas, going through a red light. Officer initiated a traffic stop and began pursuing the two speeding trucks. Officer began to call out the pursuit and advised the dispatch that the vehicles were traveling 120 to 45.
What?
120 and a 45.
120 miles an hour and a 45?
Officer was able to stop one vehicle. The vehicle pulled over and struck a curb multiple times and nearly struck a guardrail. The vehicle finally stopped. Officer conducted a felony stop on the vehicle and told the defendant to step out. While detaining the defendant, officer smelled an odor of alcoholic beverage coming from the defendant's breath. Officer placed the defendant in the patrol vehicle and searched the defendant's vehicle. Incident to arrest. Officer noticed spilled Corona beer bottle laying on the passenger floorboard.
Well, that's all we need now.
SFSTs were conducted, 6 out of 6 HGN, 3 out of 8 walk and turn, 1 out of 4 one leg stand, DIC red in Spanish, sensitive to breath, 0.146, 0.151.
Mr. Rico Romero, I'm going to find that there's probable cause to go forward with your case. Look at me. I would hope that it's elementary that you're not supposed to have alcohol in the car while you drive. You are lucky that you didn't hit and kill anyone at 120 miles an hour. This is now an affidavit, a promise that you're going to make to me that you're not to drive for any reason. I don't care what your reason is. If I find that you drive, I will have a contempt of court hearing. You will be facing an additional 6 months in jail every time you get in a car and drive. I don't care if Queen Victoria needs to ride to church. You get in a car and drive, you will be doing a lot of jail time. And if you're not in this country with permission and you go to jail, immigration will find you and they will put a detainer on you. And you will be stuck like Chuck in jail for the next year, waiting on what immigration does to you. You understand? You are extremely lucky as it is to be out of jail now, because not many people are able to post an immigration bond.
What was that last part, Your Honor?
Not many people are able to post an immigration bond. I am also ordering you not to consume alcohol or illegal drugs, and I'm going to test you. If you drink alcohol, if you use drugs, even worse, get in a car and drive, I will put you in jail for a long time. Do you understand?
Yes, Senor. Yes, Your Honor.
As it stands, the fact that you have alcohol in the car is called an open container violation. That in and of itself is a minimum of 5 days in jail. And I guarantee if you do 5 days, immigration will put a detainer on you. I would be careful, very, very careful from now on, because you're walking on thin ice. If that ice cracks, your butt's gonna freeze.
Si hielo muy delgado, si ese hielo se fractura, su culo se va a congelar.
You have a lawyer.
Tiene abogado.
Because you have a lawyer, I will waive your appearance.
Thank you.
But it's your responsibility to stay in touch with Mr. Paz. If he comes back to me and tells me he can't get a hold of you because you're playing games, I will revoke your bond. If I have to put you in jail because you're acting like a fool or not following conditions, you will not get another PR bond. You will be stuck in jail for a long time.
Una cárcel por mucho tiempo.
Do you understand what's expected of you?
Lo que se espera de usted. Yes, Your Honor.
Good luck.
Buena suerte.
Thank you, Your Honor. Maybe
Yes.
Mr. Izquierdo, apologize about being late today, Your Honor. I had a heavy
On
morning.
trial, don't worry about it.
Thank you.
Been great.
Whew, what a day. That was a long one. Man, okay. I am never going to post another jury selection again. I'll post it in Patreon, but I'm not going to stream it because that was too much. That was way too much. Thanks everyone for coming out. I really, really, really appreciate it. And for staying for a whole shift of a job almost. Oh man. I got a good one for Sunday. I just don't know what time I'm going to play it on Sunday. It's a train wreck of a hearing. That's great. But maybe I'll just put it up as a video and then you guys can watch it whenever you want. I don't know yet. We'll see. All right. We're done with the divorce trials. We're going back tomorrow to regular clips and then, of course, Fleischer. Thanks for everybody who came out. Thanks for chat. Love you all so much.